Z 53 of 2020. We have dismissed the appeal. We have recorded our appreciation for the amicus. I for? When do you want? 13th. Have it on 14th. 14th. Yes. So Monday is a holiday. Have it on 14th. Item 1.
Section 28, Adjournment 151, for passing of judgment and decree passed by Principal Judge Family Court Class Teacher on STK 313. But here this major logic, the parties have come in colonize the marriage on 7 feet.
Where is your amended cost setting? Where is your amended cost setting?
Amended, yes.
What is the amendment?
By mistake, you mentioned the section 151 where
You have to mention 151. Was that the intent of the court? You have not even understood the court's intent. The decree, the order of is of whom? Which court?
Principal Judge.
Principal judge of what?
Family Court Class.
So which act will be applicable? You have done the amendment by inserting 151 of the CPC. That was the intent of the court. With this level, nothing is going to work out. Where is your Family Courts Act? Family Courts Act. Where is the Family Courts Act? Where was the adjournment done on given on 29/1? Did you even ponder? It is not to incorporate 151. You don't need to incorporate 151 when there is an appellate provision. Family Courts Act has a appellate provision. It is a non-obstante clause. You have to prefer this appeal under section 19, not under 28. Sorry, you should understand these are preliminary things. And appeal is a matter of right. You are taking so much of time in the admission part. You don't even need to say anything. It's a statutory appeal. We'll admit it. But at least put the proper provision of law. You do it, it's not difficult. It's just one page. Though an amended cost settle has been filed pursuant to the order dated 29/1/2025, we have noticed that even in the amended cost settle, the appropriate provision of law has under which the appeal lies has not been mentioned. Full stop. Your name?
A. Mena.
A.
Mena.
Sorry, A. Mena, learned counsel for the appellant prays for and is granted 2 weeks' time to file amended cost settle. Have you understood what we have said? Take the Family Courts Act, look at section 19, then you read 28 also. Why we are asking you to file under 19? Okay.
Well,
Item 2. not an application, madam. It is an appeal.
Appeal.
Don't say an application.
Against the order dated by the 23/2005.
You are the husband.
Yes.
you're the-
Order.
You are the husband.
Yes.
Your application suit was for what? Suit was for what? The suit before the family court was for what?
Yes, for the format of the against the said order dated by the Louis order whereby matter the external directive to pay an amount of 9,000 per month.
No, you are agreed by a maintenance order.
Maintenance present right. Yes, for the maintenance present. As matter giving the external matter of contract.
Family court said.
In this case, matter what to matter the evidence filing application framed for a degree of before the landed report. And in that case matter, the respondent filed this matter, this case matter for paying for maintenance present right. And during the pending of the same case matter, the respondent filed a DP case matter before the landed report. And in that case matter, the landed court below matter, after deducting the matter, affidavit or SNL liabilities matter of the affidavit, was pleased to pass an order matter on matter 2011-2024 matter.
Regarding under what provision? That order of maintenance is under what provision?
Return matter under section 36 matter, previous section 36 matter of the expression medical.
No. The payment of maintenance
Yes.
is under what provision of law?
Maintenance present right matter under section 24 of the Independent Act and 36, related section 36 of the expression merit act. And C5 respondent file matter one another case matter in DP case matter. In that DP case also matter, the landed court was directed to direct the appealant matter to pay an amount of 5,000 per month as interim maintenance. And after that matter, that amount is paying.
Let us see where is the impugned order.
Relevant person matter is page number 137. Document line matter.
Paragraph.
Paragraph matter, mark matter after 5 lines. To make payment of 5,000 per month to the petition as maintenance present right till the disposal of the same in this case matter filed by the applicant. And this amount includes the cost of the proceeding.
What do you do?
I am working in the legal department, getting a salary of 41,000. I have annexed my salary certificate.
So what is your difficulty?
Actually, my IM is only 9 pass. Affiliate.
No. What is the difficulty in paying 9,000? No, no, see, the maintenance, whatever has to be consolidated now after Resignation, it cannot be separate. Did you point this out to the learned court that you are paying some amount under the DV in the DV proceeding?
DV case is going on, my God. I am paying the same 5,000 in this matter. Now, whatever, my God, I am compelled to leave my social quarter.
No, madam, what we are asking, the fact that you are paying certain amount under the in the DV proceeding
Yes.
in another court, that is in the court of the magistrate. Was this fact brought to the notice of the learned family court? Did you bring it to the notice?
Yes, madam.
Where is the order? Where in the impugned? No, in the impugned order it is not reflected.
Yes, madam. That is my and without considering my ability and resident language, the blood assembly court might have found this in the order.
Where is Resignation?
So this now whether there is a stopping.
You should bring Resignation at least. That part you could have. Where have you stated that you are paying so and so amount in the DV proceeding?
Pending matter, so many that.
No, where have you stated that this matter was, this fact was brought to the notice?
Not here, right, but we have my Paris mother does say copy matter in the family court.
No, it should be there. It's there. Where is the order? Page, no, the DV order, page 67. Where is the statement that you are paying, indeed paying this amount?
But I am paying matter.
Now, where is the statement that you are paying this amount? One six.
Page number 9.
Okay. Third, Miss B. Saikya, learned counsel, who has preferred this appeal under section 19 of the Family Courts Act against the order that is so and so passed by so and so. By the impugned order, comma, the learned family court has directed to pay an amount of rupees 9,000 per month as maintenance pendency light. But this pendency light, isn't it an interim order, interlocutory order? No, this petition has been disposed of. Order is interlocutory in nature. It's pendency light. If it is interlocutory order, will an appeal lie? Well, how is it in a final order? Proceedings have not come to an end. It is an interlocutory order. This case disposal is not the finality of the matter. This case is only for maintenance pendency light till your proceeding goes on. Your cause of action would have been espoused under 19.4. Have 19.4 of the Family Codes Act. Family Codes Act. Maintenance penalty right is an interlocutory order. It cannot be a final order.
91 also.
91, not. Then read the entire 91. Please read. Save as, please read 91. But read 19, your remedies are not closed. Read 19.4. Where is your act? That is not the act. What is that? Family Code Act. Please read 19.4.
19.4 was the High Court may fix money to the otherwise called for examining the record with proceedings to the Supreme Court. Restriction passing under section 9 of the Code of
Interlocutory order, appeal. Difficult, otherwise you don't have any problem with your submission. If it is not in interlocutory order, it is there is a provision of revision here. So the revision is also being under section 9. Section 9 is clear. Not because 24 or 36. People like really less. People do 24. People do 24. Madam, have you examined under what provision you can come to the High Court or any higher court? Because if you come to 19.4, that revision power is only for an order that's out. Here it is not under 125. And this 4 APC, no appeal will lie. Have you got 19.2? 19.2. So the provision for subsection 4 it gives you a window. How do you raise your grievance? 4 says the High Court may on its own motion or otherwise call for and examine the record in any proceeding in which the family court situated within the jurisdiction pass an order under chapter 9 of the, that means any order under 125, you can file a revision. But it is restricted only to a 125 proceeding, not to 24 or 36. So what is your remedy? I think you should invoke 227. That is the only thing. No, you just show us under what provision appeal will be maintainable. That is what we are asking. We are not closing the doors for you to be aggrieved or raise the issue. But in what manner? Not as an appeal. 19.1, there is a bar for interlocutory order. Maintenance pendency light is obviously an interlocutory order. It's not a finality of the proceedings. Madam, you do not go by disposal of an application. What is the order passed? Order is not final. This will depend on the final order passed in your divorce petition. This is pendency light. What is pendency light? Till the case, till the pendency of the litigation. That is the meaning of pendency light. This is something very interlocutory in nature. I think the remedy is 227. We're just thinking aloud. Yes, madam. You don't say that I only do criminal cases.
Apart from 1904, of course, 125 proceeding you cannot count. But
No, 94 he can come as a revision.
as a division.
Yes, not as an appeal. Yes.
91 said.
19(1) says no, you cannot file an appeal against interlocutory order.
Now the issue is whether maintenance part is an issue.
Maintenance pendency light. That has to be interlocutory. Till when? Intermediary, interlocutory. This is very, very fine difference, but ultimately this order will depend on the outcome of the proceedings. So it has to be an interlocutory order.
Judgment has to be same, whether it is intermediate.
No, we cannot close her doors to be aggrieved. She has a very good case. Rajneesh Neha said that you cannot go for separate maintenance. It has to be taken as a whole. If she is already paying 5,000, then if 9,000 has to be included, has to include 5,000. So that is.
Already maintenance is there. Now, if after pointing out family court gives that, family court is there.
No, but why should we remand her back to the family court, and under what provision? First, we need to have our jurisdiction to enter into this matter.
Now, whether that is an interlocutory order, if it is.
I think-
There is a bar.
I think 227 will be the best course.
As Supreme Court has defined what is interlocutory and what is intermediate. Intermediate is where some rights are established, some rights are given, some do.
This is only for the pendency of the proceedings. Maintenance till end of the litigation. This was the pendency of the litigation. You explore the option. If you convert, if you file a 227, it will be very easy for both you and for the court to invoke jurisdiction. Otherwise, 19 appeal definitely not be maintainable. For Ms. B. Sekia, learned concepts, who has referred this appeal under so and so, so and so. It has been contended that though by the impugned order, an amount of rupees 9,000 per month is directed to be paid as maintenance pendency light till disposal of FC civil case number 498 of 2024, the learned family court has failed to take into consideration that the appellant is already paying an amount of rupees 5,000 as per an order passed in a review proceedings, being review proceeding 98 of 2024. In this regard, she has placed before us the decision of the Honorable Supreme Court in the case of Rajneesh versus Neha reported in so and so, in which there is a direction on the overlapping of jurisdiction. Though YFSI or case appears to have been made out, it however appears that an appeal under section 19 of the Family Courts Act 1984 may not be the correct mode for redressal of such grievance. Full stop. While section 19(1), which provides for an appeal, clearly lays down that no appeal will be maintainable against an interlocutory order, comma. 19(2) also provides that any order passed under chapter 9 of the CRPC shall not be appealable. Full stop. The window for approaching the High Court by way of a revision has been made in section 19 within bracket 4, which however is restricted to any order passed under chapter 9 of the CRPC. Full stop. In the instant case, the impugned order has been passed by invoking section 24 of the Hindu Marriage Act and Hindu Marriage Act 24. Hindu Marriage Act, as well as section 36 of the Special Marriage Act. Under those facts and circumstances, comma, the maintainability of the appeal would itself be an issue. Sarah, at this stage, Ms. Paikya, the learned counsel prays for some time to obtain instructions. Sarah, please, Dr. Ravi.
Essentially, item was carrying the transfer for my fault. I did not mention this. I had to take consent from my management.
Hearing,
Hearing that item 50%. Maybe take it on some other day.
There is some urgency or we
In 60%. After 1 week or 2.
mentioning hours is at 10:30, madam. Why do you mention create an embarrassing situation? Yes, Mr. Bowman. When?
My learned friend has got some difficulty today.
What is the appeal about?
It is against the admission in degree of family code.
That we know. What is it about?
That talaknama executed by the husband has been declared to be null and void. And the marriage has been declared to be continuing and public.
Now, what provision the family court was approached?
Under the family code, that
Under what provision? No, what was the provision you had approached the family court? You paid for conjugal restitution of conjugal rights or what?
no,
Then?
a suit was matrimonial suit was filed.
For what? Under what provision?
What you are coming. For a declaration that the talaknama is illegal. By the way. Under section 7A, there is explanation B to section 7 of the Family Code.
The family court can act as a civil court, district court.
But it reads a suit of proceeding for a declaration as to the validity of a marriage as to matrimonial status of an person.
Is a prayer for adjournment has been made by Ms. R. Chaudhary, learned counsel for the appellant. Also heard Sri P. Bhomik, learned counsel for the respondent who has expressed urgency. Para, in view of the above, though the matter is adjourned, the same is directed to be listed when.
Such a short date,
Tell us,
Tuesday, yes, sir.
22nd,
22nd.
yes,
Thursday.
Thursday, 22.
Okay.
Item 3. Yellow page. Who's there? Is it admitted? It's not admitted.
Mark of case written on 26th of April 25. Adjourned for 2 weeks admitted.
No, the delay condemnation was allowed. Because we find that it was barred by time of 198 days. So obviously there would have been an IA, which has been allowed.
There was a magistrate also that time. The name is not reflected.
So I can also do. Legal R Islam. R Islam. Okay. Though this appeal has been listed for admission, it appears that the appeal, which has been preferred from jail, was barred by time, and accordingly, IA Criminal 224 of 2025 was filed by Sri R. Islam, learned legal aid counsel. The said IA was allowed on 25/4/2025, directing listing of this appeal for admission. So, however, the name of the learned legal aid counsel Sri R. Islam is not reflected in the court list para list after a week by reflecting the name of Sri R. Islam, learned legal aid counsel for the appellant in the court list. Para Ms. Jahan, learned APP, is present for the state of Assam.
Item 4.
Yes. Madam Sultana. Yes. Your legal aid counsel. 302. Yes. Heard Ms. B.R.A. Sultana, learned counsel for the. Madam, when you file an appeal as a legal aid counsel or otherwise, do not address the court. There is no requirement. Appeal is a continuation. There is no requirement to address. It's not an application. B.R.A. Sultana, learned counsel for the appellant who has preferred this appeal under students. Madam, why have you written sessions? Judge come special judge in POXO. Why have you written POXO? It was initially under POXO or what? Madam? No, that is okay. So that additional part, the come special judge is not connected here. He acted as an additional session judge. That is creating a little bit of confusion. So admit, call for the records. Miss L. Jahan, state respondent. Steps for service of notice upon respondent number 2 in the manner prescribed. Steps within 2 working days. List after 6 weeks. along with list for service report, no, for a report on receipt of records as well as service upon the respondent. Yes. Report admin call the records to eligible. Admin call.
Then file.
Yes, Mr. Chanda, what is this? Under POXO. Heard V.K. Chandak, Learned Counsel for the appellant who has preferred this appeal under so and insurance. That will call for the records, but it's a POXO number 2 to hold. To be routed to the office of the PPS. Steps within 2 working days, but in the case. Okay. You take steps within 2 working days. Give copy to madam. In the manner prescribed, which is to be routed through. Why are you involving the registry for giving the copy?
This is what registry will serve it to us, then we will send it to.
No, does registry annex some notice also?
They annex one.
Oh, that is the order copy perhaps.
Yeah, the order copy.
Item 6.
Yes, orders, why? 2017 appeal.
The meantime, they have paid 1,30,000. Out of 3,15,000.
Matter resolved.
They made a part of it of the maintenance.
My friend was.
No, we have taken into account 2 things on the last occasion. One was the pending maintenance and one was the resolution of the entire dispute. Have you worked out on any of the things? He will withdraw. You are the appellant here. There are 2 matter below what? Oh, you, okay. You are the wife. You are, okay. Now, when are you paying the entire maintenance amount? Thereafter, you can resolve the matter. The heard Sri B.P. Sinha, Learned Counsel for the appellant, as well as Miss P. Chakraborty, Learned Counsel for the respondent. Pursuant to the last order dated 25/4/2025, the Learned Counsel have informed that an amount of rupees
Remaining 2,16,000.
what has been paid? That an amount of rupees
130.
1,38,000 has been 1,30,000. 1,30,000
Out of 3,40,000.
has been paid, and a balance of 218.
230.
To a balance of rupees 2,13,000 is remaining. Full stop. Miss Chakraborty, the Learned Counsel for the respondent, has submitted that the balance amount would also be paid within a period of a month from today, whereafter the aspect of resolving the matter would be taken up in the right earnest. In view of the aforesaid submission, the appeal is adjourned by a month to enable the parties to take necessary steps for resolution of their disputes out of court. There are list after a month. Items again.
Document also.
Page 12 of what? Page 12 of what?
That's affidavit. That's my own additional affidavit.
Hmm. No, what is the, in this medical, what do you want to show?
Page 11,
11. How do you now, where is the urgency or something? Cholesterol is 228, which is very, very normal. Your triglyceride is 110. You should be very happy with your health. People are running, playing badminton in the morning. Nothing is happening.
page 11 is the fact copy.
11A. Yes, we have seen. After clinical examination and investigation, it is found that it has been suffering. He has been suffering from ischemic heart disease with myocardial infarction. He is now under conservative treatment and is advised to attend.
Resident, that's for my, all documents is in the federal record, so it is in
No, you see, Mr. Ahmed, we, in an appropriate case, we indeed will apply our mind, but here nothing has been made out. 70 years, okay, 70 years. Your creatinine is 1.66, urea 58, all marginal. Uric acid is 6.5. Ahmed, before you make the submission, have you noted the date? These are recent documents, April 2025. These not old documents. Bring us some documents. 19 matter paper book there. Why didn't you press for the appeal? We'll hear the appeal. 19 matter, we are hearing 22 matter, 23 matter, as you know. Where is the paper book? How many witnesses? Mr. Ahmed, for your benefit, we are saying, instead of spending time asking her to bring a report, we'll have this for hearing on Thursday. Thursday hearing. Okay. Conviction under what? It will take more time. We are giving on Thursday. So why are you shy on coming up ahead with the appeal? No, Thursday we are hearing the matter. What is your difficulty? You have a bad case. Thursday will hear the matter. Will it be possible to have a report on Thursday? Monday is a holiday. We don't know why you are shying away from doing the appeal. Otherwise, you are very eager to deal cases. Why this case? There's some difficulty over it. Then we will have the appeal for hearing. These are not very convincing. heard Sri A. Ahmed, learned counsel for the applicant appellant. Also heard Ms. Jahan, learned APP Assam. Full stop. In the IA, which was filed in the year 2019 itself, praying for suspension of sentence, comma. An additional affidavit has been filed on 2nd of May 2025, annexing certain documents regarding the health of the applicant number 1. Full stop. The same has been produced. Full stop. But the same has been produced, which, however, does not show any abnormal conditions, abnormal medical condition of the applicant. Full stop. The learned counsel for the applicant has, however, submitted that as per instructions received, the applicant number 1 is bedridden and is seriously ill. Full stop. Be that as it may, we are of the opinion that since the appeal is of the year 2019 and the paper book has been prepared, the appeal itself can be heard. Full stop. As urgency has been expressed, we direct listing of this appeal for hearing on Thursday. All right. No private respondents, ma'am. Affidavit. Item number. Paperwork not ready. Paperwork ready. 17 February 2020. Where? In the IA? Yes, Mr. Ahmed. Where are you? Yeah, Ahmed. Only he's there, amicus. Ask him to come. Now we had noticed that it's a conviction under POCSO. So on the last occasion, after holding that the service is complete, we had appointed Mr. Ahmed as amicus. No, not sure. Well, ask him. Why the order dated 17/2/2025 passed in the connected IA. ইয়াতে আহিব লাগিছিল কিয় অহা নাই আকৌ এই অৰ্ডাৰটো দুটাত আহিব লাগিছিল এপিলটো আহিব লাগিছিল Mr. Ahmed, in one of the matters we had appointed you amicus in February in a POCSO matter to appear for the victim. Your name has not been reflected. Please take note. Okay. Paper book is yet to be prepared. They are seeking adjournment, but we are asking we are directing of this case by showing your name. Passed in the connected I criminal 469 of 2024. Service upon the respondent number 2 was held to be complete, and since the conviction and sentence involve the POCSO Act, we had appointed Sri A. Ahmed as the amicus to appear for the victim. Para. The name of the learned amicus has, however, not been reflected in the court list. Para. List after a week by reflecting the name of Sri A. Amit as amicus curiae for the respondent number 2. No, we'll let the paper book after preparation. The paper book has not been prepared. You have to visit Mariba. Appeal to Mariba. Why 2 appeals? Okay, 158 is the appeal.
Item 9.
Yes, Mr. Aluri.
But the IAs for the system of tendency, they block. The picture has been filed by the state.
The conviction is under what?
395. That was the. Lord, my case is definitely.
396 is a very dangerous section.
But
The punishment may go for
even, that's it.
Death. Death.
Minimum
Very few of the thing where death is also prescribed.
But when the FIR, our name will not appear,
Doesn't matter.
the unknown miscreant.
Doesn't matter.
In evidence also, not,
Yes, madam, your objection filed.
objection. Objection filed.
Who is your colleague? Who is the colleague? Who is it?
Yes, we have a second.
Madam, Bhuyan has filed.
The copy is also with her. Normally it is kept by her.
Okay, we'll have it on Tuesday or Wednesday next. Okay. Okay, it can be done. Heard. 3. Hello. Came hello, learned counsel for the applicants, 2 applicants. As well as Ms. H. Jahan, learned APP Assam. Ms. Jahan has informed that objection in the IA has been filed by one of her colleagues, who however is not present today in the court. And accordingly, she prays for some accommodation. Para, as agreed to by the parties, matter is adjourned, will stay on Thursday next date.
Item 10.
For?
I'm appearing for the applicant. This application is for combination of delay of 321 days. The reason behind the delay was the illness of the previous conducting counsel. The documents with regard to his health, he has undergone an.
You are appearing as a legal aid counsel,
No,
as a private counsel.
Yes.
You have newly entered appearance.
I filed the comparison with this. Previous conducting counsel had undergone an operation in the month of May 2024, and thereafter he has gone for checkup to.
Okay. And madam, notice is yet to be issued here. Doesn't matter. For Dr. P. Agarwal, learned counsel for the applicant, as well as Miss H. Jahan, learned APP Assam. Correct? The instant application has been filed under Section 5 of the Limitation Act 1963 for condonation of delay of 321 days in preferring the connected appeal. The appeal has been preferred against a judgment and order it is so and so, passed by so and so, whereby so and so. Okay. Correct? Dr. Ahmed, Dr. Agarwal, the learned counsel, by drawing the attention of this court to the averments made in paragraph 6 and 7, has submitted that the delay has occasioned because of factors which were not within the control of the applicant. Full stop. She has also cited that the earlier counsel who was engaged was seriously ill, as a result of which the appeal could not be preferred in time. She accordingly submits that the delay may be condoned and the appeal be admitted. Full stop. Para. Ms. Jahan, the learned APP, has submitted that the delay is of 321 days, which is a long delay. She, however, fairly submits that since the appeal is preferred against a judgment of conviction and sentence, she would not have serious objections in the prayer for condemnation of delay and would rather oppose the appeal upon its admission. Para. It is a subtle position of law that while adjudicating a delay condemnation application, a pragmatic and justice-oriented approach is to be taken. We have also perused the reasons cited in the application which concerns the ailment of the earlier counsel who was entrusted with the matter. Full stop. Para. Considering the above, we are of the view that a case for condemnation of delay has been made out, which we accordingly do. Para. The IA stands allowed. Para. The appeal may accordingly be registered and listed for admission after a week.
Along the IS.
Appeal along with any IA, along with IA, maybe, huh? Complete. Who is appearing? Boxo. But this is not through you, but doesn't matter, it is complete. Your A. Hussain, heard Sri A. Hussain, learned counsel for the applicant, who submits that notice upon the respondent number 2 has been served. Full stop. We have perused the returned the document which has been placed with the record after return of service. Full stop. Though the service does not appear to be done strictly in accordance with the procedure laid down in Deepak Nayak. Deepak Nayak. In the case of Deepak Nayak, the endorsement made therein, including that of the in charge of the Lalpani outpost, Udalguri, would show that the notice was indeed served. Para. Accordingly, we hold the service upon the respondent number 2 to be complete. Para. Since the conviction and sentence involves the POXO Act and the respondent number 2 has not entered appearance, comma, we Yes, Madam Dipanjali. You are not an amicus. Legal aid can be appointed or not? Can be appointed, no. You are, you are not a friend of the court. Madam Jahan, she is not a friend of the court. So why should we extend a hand of friendship to her? Not possible. No, it should be, I think, amicus. You're her counsel. Appears so. Immediate engagement. Okay, we appoint Ms. Dipanjali Borpujari, learned legal aid counsel, to appear on behalf of the respondent number 2. Full stop. Let a copy of the IA be served upon her and the matter be listed for consideration after 2 weeks.
Well, if the part of the LCR has not been listed.
I see. Since it appears that the LCR has not been received this year, received pursuant to the order dated 26/3/2025, comma, office to issue a reminder for requisitioning the TCR. Well.
Before I begin, just one number. This is my first time, this type of matter here, so I thank for forgiveness in anticipation.
No. There's nothing. What is the matter about? What is your name?
This is the appeal.
What is your name?
Written by your.
R. Bhuya.
Yes, sir.
Application under section 5.
Yes, sir.
How many days delay?
Doctor, delay of 151 days.
In
Till the date of,
in what? Delay in?
filing this particular appeal.
What is section 5 of the Limitation Act?
Doctor, it states that any appeal of this sort ought to be filed within a period of 30 days since the date of conviction.
30 days.
Okay. Sorry, 60 days. Sir.
Now, what is section 5? What is section 5 of the Limitation Act?
Doctor, it pertains to the validation of delay.
What does it state?
It states that appeals against any conviction, especially with regard to
Appeals against any conviction. What is the language of section 5?
I don't know the exact location.
You should have. You ask for forgiveness. You should not ask for forgiveness. You should be prepared with matters. You will have your matter after some time. Bring the Limitation Act and whatever you think would be the question coming from the court. You'll have to answer the questions after 15 minutes. Item 13. Yes.
It's the message of your lordship, limited Monica, this week your lordship, legal service authority has forwarded to Committee High Court, your lordship. Well, giving this.
Okay, issue notice. POXO. Madam.
And your, also your lordship, life imprisonment is also there.
I heard Ms. P. Das, learned counsel. legal aid counsel, who has filed this application under Section 5 of the Limitation Act 1963 for condonation of delay of 107 days in preferring the connected appeal. The appeal has been preferred against so and so, huh? Para, issue notice. Returnable by 6 weeks. Ms. Jahan Learned APP accepts notice on behalf of respondent number 1. Who is respondent number 2, madam?
The informant, your lordship. Your lordship, there is two person, your lordship, that is SI Amir Hussain, he is SI, your lordship, at the time while that the complainant has been written, your lordship, on behalf of publisher Niti, who is the main informant here, your lordship.
Why do you make the SI party? What is the
Because
purpose?
he did lodge the FIR, your lordship.
What is the purpose of giving a notice? It is only the victim or victim's family.
Lordship, I will take the state for respondent.
Unnecessarily, you are making us SI Amir Hussain. He has done a very mechanical part. He will not defend. His defense will be done by the state.
In fact, the combination maybe was a relation. He is also in a way related to the victim.
But still, then at least he can.
Given that complainant, your lordship.
You should identify who is the victim or her guardian. Then make him or her a party.
Here, your lordship, very unfortunately, the victim was your lordship, that the daughter's father is.
Then you make the victim. Okay, let steps for service of notice upon the respondent number 2 and 3 be taken, which is to be routed through the office of the learned PP. Assam. Steps within 2 working days. Para, list up to 6 weeks for service report upon the respondent numbers 2 and 3, and for filing objections, comma, if any.
And the your.
14.
One day.
Boxo. You are her counsel.
That's
You are not opposite. I think you should recuse from the case. Ms. D. Counsel for the applicant who has preferred this application under Section 5 of the Limitation Act for condonation of delay of 41 days in preferring the appeal. Para, the appeal has been preferred against judgment in the instance. Para. The learned legal aid counsel, support legal aid counsel, legal aid counsel. Your legal aid counsel. The learned legal aid counsel has drawn the attention of this court to, has submitted that the matter has been handled by the High Court Legal Aid Service Committee, and the concerned documents had to be procured from the learned trial court by referring to the averments made in paragraph 10, 9 and 10 of the application. The learned counsel has submitted that the delay has occasioned due to factors which were beyond her control. Full stop. Para. Ms. Jahan, the learned APP, has Friday submitted that the appeal being against an order of conviction and sentence, she would not have serious objection for condonation of delay and would rather oppose the appeal on merits. Correct? It is a settled position of law that while adjudicating an application for condonation or delay, a pragmatic and justice-oriented approach is to be taken. We have also perused the grounds cited for delay of 41 days, which is found to be satisfactory, and the delay itself does not appear to be inordinate. In view of the above, we are of the opinion that the delay of 41 days is required to be condoned, which we accordingly do. I accordingly stands allowed. The appeal may accordingly be registered and listed for admission after a week.
Item 12,
Yes, Mr. Bhaiya. Hold on, listen again. Yes. What is section 5 of the Limitation Act?
Section 5 speaks as to how any other appeal or application other than any application made under the provisions of Order 21 of the CBC can be admitted even after the expiration of the prescribed period if the appellant can satisfy this court with sufficient cause as to why this delay had happened.
Please read section 5.
Section 5, extension of prescribed period in certain cases. Any appeal or any application other than application under any of the provisions of Order 21 of the Code of Civil Procedure 1908, 5 of 1908 may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period.
Okay. So this connecting is an appeal. Is in connection of an appeal that you have filed the application.
Yes.
What is the period of limitation prescribed?
30 days as per the Act.
30 days.
Sorry, 60.
Under what provision?
Section 14.
No, not section. You should bring the barrack. You are a young counsel, don't depend on your software. Bring the barrack. You should have the barrack. There is a schedule to the Limitation Act. Come to the schedule. Have you got the schedule?
That's what.
Yes, in the schedule, the period of limitation has been prescribed for various causes of action. And what is your cause of action? What you are aggrieved by what?
An order in judgment
Yes,
has convicted the present appellant
yes,
for a conviction under
yes,
Section 6 of Procedural.
yes. Which would be the article in this schedule? Come to 115.
Yes, sir. Honest.
Please read. What is there?
Under the Code of Criminal Procedure 1898, 5 of 1898, from sentence of death passed by a court of session or by a high court in the exercise of its original criminal jurisdiction.
So is it your death sentence?
No.
So it is not there. So B,
B, from any other sentence or any order not being an order of acquittal to the High Court through any other courts. For
Okay.
the High Court, 60 days.
60 days.
For any other court, 30 days.
Okay. Then to High Court, it is 60 days.
Yes, sir.
What are the causes you have assigned?
Lordship, here in this application causes that we have mentioned, Lordship, is the fact that the appellant has an old and ailing mother, a sister who is already married off, and his wife, Lordship. The sister has been married off, and the family has been primarily surviving on income generated primarily from agriculture, and was often just supplemented by the odd jobs that this particular applicant would do. They don't have a lot of education, in fact, next to none. Lordship, the fact is that
Where have you stated? What have you stated? You have a married wife, you have an ailing mother. What have you stated? What is the reason for delay? You get 60 days to approach the court.
yes, sir. Lordship, the family of the appellant could not leave his ailing mother in the village to fend for herself, and coupled with the fact that there was severe financial crisis, they could not.
Where have you stated?
Lordship, paragraph 3, Lordship.
Yes, please read.
That's the last portion of paragraph 2, Lordship, and paragraph 3. I can read paragraph.
Please read.
That's the petitioner has filed the criminal appeal on 8th of April 2025, which he ought to have filed on the 28th of September 2024. However, he unfortunately could not file the said criminal appeal within the stipulated period as provided under the relevant provisions of the Limitation Act, as because there is no one in his family except for his ailing mother, who has an illiterate rustic village woman, to pursue this case, his own sister who served as a witness during the trial for the petitioner. Paragraph 3. That ultimately his sister, accompanied by a neighbor, the petitioner's wife, and brother-in-law, could manage to meet petitioner in Lakhimpur jail on.
Yes,
029.
we have read this. Yes, what is the case law on condemnation application? We have been saying, you've been hearing that you need to have a pragmatic approach, justice oriented. What are the cases where it has been said that while adjudicating an application for delay condemnation, we have to have a lenient approach, justice oriented approach. At the same time, if the delay is intentional, then we need to be strict. What is the case law? You should come up with case laws. Don't take things for granted. You should have the case law. If you'd be interested, yes, I should know how would this application be treated by the court. Heard Sri R. Bhuyan Learned Counsel for the applicant who has filed this application under section 5 so and so for the condemnation below 151 days in preferring the connected appeal. The appeal has been preferred for so and so. Paragraphs 3 and 4. Okay. Delay condemn. Oh. Is there any POXO? Then 3 and 4. Oh, no, I have to go. That's so there's a private respondent. No, I will read. Issue notice. Ms. Jahan Lanitz, APP, accept notice on behalf of respond number 1 state. That step will be taken upon 2. Okay, 6 weeks for service report as well as for filing of existence event. You have to take steps. Give copies to madam.
Then 17, supply list. Yesterday, I was in the point of circumstantial evidence and how circumstantial evidence to be appreciated, as well as this extra judicial confession. So I was relying on the case law of 2025 3 565, Ramo Appa Mahapatra versus State of Maharashtra. And the paragraph lordship I mentioned were 19 to 26. I was reading 19, I just completed 19 yesterday. So I stopped at 20 version. State of Rajasthan versus Rajaram, this court explained the concept of extrajudicial confession. Confession may be divided into two classes, that is, judicial and extrajudicial. Judicial confessions are those which are made before a magistrate or a court in the course of judicial proceedings. Extrajudicial confessions are those which are made by the party elsewhere than before a magistrate or a court. Extrajudicial confessions are generally those that are made by a party before a private individual who may be a judicial officer or a judicial officer also in his private capacity. As to extrajudicial confessions, two questions arise. Firstly, whether they are made voluntarily. Second, are they true? If the court is of the opinion that the confession was not made voluntarily, but was a result of an inducement, threat or promise, it would not be acted on. It follows that a confession would be voluntary if it is made by the accused in a fixed state of mind, and if it is not caused by any inducement, threat or promise, having reference to the charge against him, proceeding from a person in authority. Whether or not the confession was voluntary will depend on the facts and circumstances of each case, judged in the light of Section 24 of the Evidence Act, 1872. The law is clear that a confession cannot be used against an accused person unless the court is satisfied that it was voluntary. At that stage, the question whether it is true or false does not arise. If the facts and circumstances surrounding the making of the confession appears to cast a doubt on the veracity and voluntariness of the confession, the court may refuse to act upon the confession if it is admissible in evidence. The question whether a confession is voluntary or not is always a question of fact. A free and voluntary confession is deserving of the highest credit because it is reason to flow from the highest sense of guilt. An extrajudicial confession is voluntary and true and made in a fit state of mind can be relied upon by the court. The confession will have to be proved like any other fact. The value of evidence as to this confession, like any other evidence, depends upon the reliability of the witness to whom it is made and who gives the evidence. Extrajudicial confession can be relied upon, and conviction can be based thereon if the evidence about the confession comes from a witness who appears to be unbiased, not even remotely inimical to the accused, or in respect of whom nothing is brought out which may tend to indicate that he may have a motive of attributing an unfruitfulness statement to the accused. The words spoken by the witness should be clear, unambiguous, and unmistakably convey that the accused is the perpetrator of the crime, and that nothing is omitted by the witness which may militate against it. After subjecting the evidence of the witness to a rigorous test of touchstone of credibility, the extrajudicial confession can be accepted and can be based of the the basis of the conviction if it passes the test of credibility. If the evidence relating to extrajudicial confession is found credible after being tested in the touchstone of credibility and acceptability, it can solely form the basis of conviction. The requirement of corroboration is a matter of prudence and not an invariable rule of law. In Census of 10 versus State of Rajasthan, this court accepted the admissibility of extrajudicial confession and held that there is no absolute rule that an extrajudicial confession can neighbor with the basis of conviction, although ordinarily an extrajudicial confession should be corroborated by some other material. Evidentiary value of extrajudicial confession was again examined in detail by this court in Sahadevan versus State of Tamil Nadu. That was also a case where conviction was based on extrajudicial confession. This court held that in a case based on circumstantial evidence, the onus lies in the prosecution to prove the complete chain of events which shall undoubtedly point towards the guilt of the accused. Yet apart, in a case of circumstantial evidence where the prosecution relies upon extrajudicial confession, the court has to examine the same with a greater degree of care and caution. An extrajudicial confession, if voluntary and true and made in a fit state of mind, can be relied upon by the court. However, the confession will have to be proved like any other fact. The value of evidence as to confession, like any other evidence, depends on the veracity of the witness to whom has been made. The court acknowledged the extrajudicial confession is a weak piece of evidence. Wherever the court intends to base a conviction on an extrajudicial confession, it must ensure that the same inspires confidence and is corroborated by the other prosecution evidence. If the extrajudicial confession suffers from material discrepancies or inherent improbabilities and does not appear to be caused, such evidence should not be considered. This court held as follows. It is settled principle of criminal jurisprudence that extrajudicial confession is a weak piece of evidence, wherever the court, upon due appreciation of the entire prosecution evidence, intends to base a conviction on extrajudicial confession, it must ensure that the same inspires confidence and is corroborated by other prosecution evidence. If, however, the extrajudicial confession suffers from material discrepancies or inherent improbabilities and does not appear to be present as per the prosecution person, it may be difficult for the court to base conviction on such confession. In such circumstances, the court would be fully justified in ruling such evidence out of consideration. So these are the principles which has been laid down. In this, in this measuring scale, also has to measure this case whether this facts and circumstances within this case. As I have pointed out, as far as this extrajudicial confession is concerned, the only two witnesses have stated about this. As far as witness number
5 and 7, let's say.
5 and 7, and as far as number 1 and 2, 1 and 2 the brothers and mother, they have not stated anything about this extrajudicial. Moreover, the other neighbors who were there, 25 people, nobody has been examined. Third aspect is that there was an assault. So whether this, if at all, Mr. Lordship thinks that like this, there was an extrajudicial confession, whether it was done voluntarily in a fit state of mind, that has to be taken into account. Because it has been specifically stated in this case that it has to be voluntary. It has to be in fit state of mind. It should not be induced. It should not be provoked. So these are the words used in this case law also. So this case has to be carried out, whether it was induced, whether it was done without any provocation, without any inducement, and that's in this particular case also there was an assault. There's specific statement by the police that the assault was made. In fact, this person was taken to the police station. The accused was taken to the police station by 3 people, and then he was sent for medical. So from the facts also, it is clearly coming that there was an assault. And if there is a mob of 15-20 people and they assault the person, and in that kind of state of mind, the person can, to save himself, he can say anything. So that cannot be taken in an extrajudicial. So in my humble your lordship, the extrajudicial confession part, taking that to be an opposite evidence, that conclusion that can be arrived by the learned trial court, that should not be taken into account. That should be not relied on. That should be negated. One more case, Your Worship, I would like to place on extrajudicial confession, which also is a recent case. So, 23 SSC online, Supreme Court 259 is Pawan Kumar Chaurasia on the state of Bihar. I just read out two paragraphs from here. Paragraph 5.
This is also on extrajudicial confession.
Yes, but that's a
Paragraphs?
paragraph 5 and paragraph 7. I just see the paragraph 5 is small, short paragraph. As far as extrajudicial confession is concerned, the law is well settled. Generally, it is a weak piece of evidence. However, a conviction can be sustained on the basis of extrajudicial confession, provided that the confession is proved to be voluntary and truthful. The two words that we use, voluntary and truthful. It should be free of any inducement. The evidentiary value of such confession also depends on the person to whom it is made. Going by the natural course of human conduct, normally a person would confide about a crime committed by him only with such a person in whom he has implicit faith. Normally, a person would not make a confession to someone who is totally a stranger to him. Moreover, the court has to be satisfied with the reliability of the confession, keeping in mind the circumstances in which it is made. As a matter of rule, corroboration is not required. However, if extrajudicial confession is corroborated by other evidence on record, it acquires more reliability. And paragraph 7 also. It's a conclusion in that particular case, but I'll just read out. Hence, the prosecution's case about extrajudicial confession does not inspire confidence at all. Moreover, there are no other circumstances brought on record which could support or corroborate the prosecution case. Therefore, in our considered view, evidence in form of extrajudicial confession of the appellant deserves to be discarded. Admittedly, there is no other evidence against the appellant. Therefore, the conviction of the appellant cannot be sustained at all. Accordingly, in judgment. So, also extrajudicial confession. So, also basically the principle has been laid out in a particular case where extrajudicial confession was not properly corroborated by any other opposing the evidence that has been discarded. Cases there on extrajudicial confession. I'll just place it before your lordship. I'll just give the paragraph in the same language. It's 2014 SSC 750. Sarendra Kasdev Paswan and others versus State of Gujarat. Paragraph 19, 20, and 20. So the same principle and lordship.
Paragraph 19.
19, 20, and 20. As far as circumstantial evidence is concerned, there are three paragraphs of kindly brought down. Paragraph 13, 14, and 15. The same case. So another case, lordship on the point of motive. In this case, also, lordship, from the materials taken before for your honor on record, the motive part is also kind of missing. Why this person is lordship this accused is a 22 years old person. His wife was probably victim was around 19 years. And after 1 year of they are married. What prompted him to kill her in front of his family members? There was nothing on record. Nothing has been shown on record saying there was a motive behind it. It's not always required, but still motive is an essential and very important aspect of criminal jurisprudence. As far as the mens rea is concerned, this is 2022 SSC Online Supreme Court 1454. Paragraph 12, 13 and 14.
Well,
12, 13 and 14. I'll just read out, it's not a very long paragraphs, but not very long paragraph. 12. In a case based on substantial evidence, motive assumes great significance. It is not as if motive alone becomes a crucial link in the case to be established by the prosecution, and in its absence, the case of
this should not be substantial, it should be circumstantial. It should be circumstantial.
yes, sir.
The starting of the line in a case based on substantial
Yes,
is
yes.
circumstantial.
Yeah, Roxy is correct. In a case based on circumstantial evidence, motive
We
is-
thought that you had read it wrong, but you had read it correctly.
in a case based on circumstantial evidence, motive assumes great significance. It is not as if motive alone becomes a crucial link in the case to be established by the prosecution, and in its absence, the case of prosecution must be decided. But at the same time, complete absence of motive assumes a different complexion, and as such, absence definitely weighs in favor of the accused. Here is a specific line, not a very clear-cut line, but at the same time, complete absence of motive assumes a different complexion, and as such, absence definitely weighs in favor of the accused. And in Anwar Ali versus State of Himachal Pradesh, this court made the legal position clear in the following words. Now, so far as the submission on behalf of the accused that in the present case, the prosecution has failed to establish and prove the motive, and therefore the accused deserves acquittal is concerned, it is true that the absence of proving the motive cannot be a ground to reject the prosecution case. It is also true, and as held by this court in Suresh Chandra Bahri versus State of Bihar, that if motive is proved that would supply a link in the chain of circumstantial evidence, but absence thereof cannot be a ground to reject the prosecution case. However, at the same time, as observed by this court in Babu, absence of motive in a case depending on circumstantial evidence is a factor that weighs in favor of the accused. In para 25 and 26, it is observed and held as under. In State of UP versus Christian Paul, this court examined the importance of motive in cases of circumstantial evidence and observed the motive is a thing which is primarily known to the accused themselves, and it is not possible for the prosecution to explain what actually promoted or excited them to commit a particular crime. The motive may be considered as a circumstance which is relevant for assessing the evidence, but if the evidence is clear and unambiguous, and the circumstances prove the guilt of the accused, the same is not taken, even if motive is not very strong one. It is also settled law that motive loses all its importance in a case where direct evidence of eyewitnesses is evident. Because even if there may be a strong motive for accused persons to commit a particular crime, they cannot be convicted if the evidence of eyewitnesses is convincing. In the same way, even if there may not be an apparent motive, but if the evidence of the eyewitnesses is clear and reliable, and the absence or inadequacy of motive cannot stand in the way of conviction. This court has also held the absence of motive in a case depending on circumstantial evidence is a factor that weighs in favor of the accused. In subsequent decision in Shivaji Chinkappa Patel versus State of Maharashtra, this court relied upon the decision of Anwar Ali and observed as under. Though in a case of direct evidence, motive is not be relevant. In a case of circumstantial evidence, motive plays an important link to complete the chain of circumstances. The motive. So also motive is an important factor. And here also, as far as my submission goes, also the prosecution, in fact, prosecution, it is correct that prosecution may not be always be successful and like it may not be on their part to like bringing what is the motive. But apparently also from the facts of the case, there was no motive. There was no apparent motive could be pointed out to the case. While was accused of so motive part is also missing, and circumstantial evidence also, as I have already pointed out, that there are certain circumstances also the circle of I mean the circle is not complete. The circle of the state is not complete because there are some contradictions. There is one contradiction which actually goes to the root of the matter. Because two persons also there which are supposedly the star witnesses, CW5 and CW5, they have stated they have in fact lied before the trial court, stating that they have intimated the police on the previous time, and the police came to their in the place of occurrence the next day and they picked up the accused. In fact, also the IO has specifically stated that these three people. Another PW8, these three people, in fact, they took the victim, took the accused to the police station and police have arrested the accused there. And after that, the person was sent to the sent for medical examination. So this is really, I mean, contradictory. Because PW1 and PW2 have a very different person. PW1 and 2 didn't say anything about selection divisions and something. So. Lordship, another thing, Lordship, that there are some vital witnesses, those have not been examined. I mean, that the boy who has intimated that the brother-in-law and mother-in-law of the accused.
But PW1 had told that the appellant had told that he beat and gave medicine. Beating part, PW1 has also told.
No, that the medicine part.
No, even beating part.
And beating part was
Come to page 10.
What I was talking about
The beating.
what's it?
Beating.
The beating is there, but like I mean the killing.
No, that beating has led to the death. He talked about the beating on that day.
And sentence that was used.
Come to page.
They have not stated.
Come to page 9. It starts at 9. Come to page 10.
When we went to the house of my sister, we found the accused in his house. On being asked him about the incident, accused told us that he beat my sister, then gave her medicine.
Yes, specific to the death. He found him
dead.
dead.
The statement was not complete. That's what I was saying. That like the statement was not complete. That he has it's not a confession of killing. It was a confession, maybe a confession or a statement about beating someone. It's not exactly killing, but the statement that they have made.
I saw her lying. When we went to the house of my sister and we found the accused in his house.
Yes.
On being asked him what about the incident, that is about the incident. The
Yes.
accused told us that he had beat my sister and gave her medicine.
That's true also, but like as
This
far as
beating is in connection with the incident. And you have to relate this with the last two lines of the first paragraph. I saw her lying there on her bed. I noticed grievous injuries on her left side of the eye. During the time of the incident, my sister was 3 months pregnant. Now he witnesses her lying there on the bed he witnesses injuries on the left side of her eye. Then he asked the accused told her, I beat her and then I gave her medicine.
That is there.
One part is there. He may be correct in contending that it's not a confession of his killing,
That's what I'm saying, that,
but,
otherwise, like, he mean, he would have stated that I killed her. But there was no statement
Between
as such. So whether it's a complaint, whether it can be taken in an extrajudicial confession of killing, then it has to examine. And in my humble submission, Lordship, from these two, at least PW1 and PW2, that extrajudicial statement of confession of killing hasn't come very clear. And another thing also, as I have pointed out, that also has to see that the circumstance at what point of time and when the extrajudicial confession was made. And the vital witnesses have been also not been examined. The one, the boy who was intimated, who was not examined, and the people who were present at the time of the incident, those people were not examined except the father of the accused. And there was inconsistency in the inquest report and the postmortem report. As I have pointed out yesterday, that as far as that injury in the head, in the forehead, nothing was mentioned in the inquest report. Then it came in the postmortem report. And postmortem report also, when I was mentioning yesterday, there was mention of blunt weapon, whether this can be taken as a blunt weapon, that also has to also looking into this person's age, he's only 22 years old. So he was at the time of incident was only 22 years old. Lordship may kindly, in my humble submission, Lordship may kindly take into all these factors, and after looking into all these factors, Lordship may decide. Lordship may take some leniency, looking to his age and his charity, and then looking into other factors. It's a case of circumstantial evidence of the law who are in place. And the Learned Trial Court is relied on circumstantial evidence and extrajudicial confession.
okay. Yes, madam.
Based on the circumstantial evidence and extrajudicial confession, may I say that about the circumstance is completed, as it is seen that the prosecution have relied that if the accused and the deceased are the husband and wife, first of all, Lordship. Then the accused and his wife were under the same roof on the night of the incident. He was there. Then the wife of the accused found dead inside the room with a head injury. The medical report confirmed that the deceased died due to head injury. But the accused made extrajudicial confession before the neighbor people who gathered there in his residence, and he had killed his wife by punching her on the head and face. While the neighbor people informed the matter to the police, the accused person tried to flee away from his residence, but later on the local people able to apprehend him. But about the punching, Lordship, that is on the medical report, Lordship, and the PM, Lordship, and
But he did not flee away.
he tried to, then local people, he tried to, Lordship, then local people.
Yes, but so I just want to one thing, that absconding part also, when this boy went and like the parents, the brother-in-law and the mother came, he did not abscond. He was, and I was talking about usually generally what happens is like if somebody commits something, like tries to clear it, but like he was there.
Lordship, regarding the Lordship punching and that is relied on medical report, page number 69, PM report. Rules and PM report, page number 69.
Just a minute, please. Just 1 minute. These are 69.
PM report. Regarding punching lottery,
Yes.
rules and position and character lottery. The third point lottery. Confusion of size 5 cm, 6 cm over the vertex of the scalp. On dissection, clothed blood found in layer of the scalp and red in color. Clothed blood found in the layer of the scalp. It can be happen through punching. Main circumstance lottery. The accused is taken the plea of poison and he fell down. The purchase is totally ruled out by medical report. Does it support that lottery? That poisonous thing is found. There it supports that it is judicial, extrajudicial confession that he died due to brain that is lordship. That was due to lordship head injury, which he confessed lordship. And the confession lordship is reliable because lordship PW1 lordship. PW1
PW1.
PW1 lordship. As PW1 has stated lordship,
Yes.
is number 9, lordship, the accused told us that he beat my sister,
Hmm.
sister, and then gave her medicine. And PW5 and PW7, they have stated that they stay in the same village, but they have no connection with the deceased lordship, that they will be something biased or have some interest upon his lordship. PW7 and PW5, they've only stated that they are of the same village. And as in extrajudicial confession lordship, if I rely upon the judgment of Aftab Ahmed Ansari lordship. I have given the document.
Citation. Citation.
Citation lordship, 2010 to
2010.
583. Paragraph 53. For 51 onwards, lordship, may I intervene?
Regarding what?
Regarding extrajudicial confession.
51.
51. The court on reappreciation of evidence finds that it is not brought on record of the case that this witness was on inimical terms with the appellant. In fact, this witness does not belong to the community of the appellant and belongs to another community. There was no earthly reason for this witness to come to the court and report falsely about the extrajudicial confession made by the appellant. It is lordship. We also don't have any such relation or such lordship. Though extrajudicial confession is considered to be a set, my learned friend who already lordship stated lordship. to be a weak piece of evidence by the court, this court finds that there is neither any rule of law nor of prudence that the evidence furnishing extrajudicial confession cannot be relied upon unless corroborated by some other credible evidence. The evidence relating to the extrajudicial confession can be acted upon if the evidence about extrajudicial confession comes from the mouth of a witness who appear to be unbiased. Same is with this 5 and 7 months. And in respect of whom even remotely nothing is brought out which may tend to indicate that he may have a motive for attributing an untruthful statement to the accused. With this question, and 7 also is unbiased person. There is no unequal doubt and not the circumstances saying it already completed but because in the circumstances we have the accused will have to prove it. As he is in the room worship, there is no other route. And it is in the you will have to prove this as lordship regarding 106 of evidence and lordship. The burden of proof lies upon him. And if we have taken lordship that he is 313 lordship.
It's not the burden of proof. First, you have to establish the foundational facts. If he is under a special knowledge, then he need to explain.
That is lordship in his 313 lordship. He has taken the plea of poison. But it is not supported.
Poison is not supported by PM report.
Not supported by PM. Then lordship is 313 lordship.
Now, question number 5. Question number 5. Question number 5. You at page 31. Consumed poison and died by falling inside the house. And question number 16 at page 33. She had consumed poison.
Some man stay like this, his wife only 1 year of marriage. Without informing doctor or without calling a doctor. He's waiting to get the wife died of consuming it. Can it be happening in the normal course of life?
What is the conviction under 302? But you have not found any weapon. Do PM says it's a blunt weapon.
It is so.
No. It is happened. See, that's as a matter of fact has happened. Nobody is denying that. But we are only exploring the other options, whether there was an intention to cause death by fist blows. No, we are not on the motive part. We are on the intention that do I intend to kill him by giving her a fist blow?
Fist blow, Lordship. First of all, he has already admitted that she is anemic. He is weak. For that purpose, he used to take medicine. He himself. Lordship, fist blow can in the hand, Lordship, in the scalp, Lordship. It is not visible. Because Lordship, sometimes a man.
No, see, if there was real intention to kill her, he could have got a heavy object on the head. There is no evidence that any object was used. That is one factor we are pre-planned.
Without that, Lordship,
You cannot,
Lordship, that if some injury may come out.
Madam, you cannot improve a prosecution case after the evidence. There is no element of any cold-blooded murder or pre-planned.
It's not there, but PM report directs it. That it is through, he died through head injury, and it is supported by the evidence. And Lordship, regarding left eye, Lordship, after 2 years, a person may forget, Lordship, which eye it was in which side. But one person has said, Lordship, PW7, that it is in the right forehead, in the cross person.
No, that is Mr. Kolita is there. It's been fairly, is not given much stress on this left side or right side. So long it is in the head and the face.
Lordship. Because PM is the same also lordship. And that is direct, it is PM in direct says lordship. She died of head injury and which is corroborated with the evidence PW. They have similar injury. Even the mother also said that previous injury, but she said that injury in her eyes. But in the
Mother was examined, mother was not examined.
mother of the deceased lordship.
This is, yeah.
This is a lordship. Moreover, lordship, though PW 4 is standard in 161, he had admitted lordship. In that is lordship, PW 10 lordship.
Let us see the contradiction so far as PW 10 hostile is concerned.
PW 10 lordship. Page number 20 is lordship.
Yes.
Second paragraph. Malik Sapan, Mura PW 4. In this statement under 161, CRPC has stated.
Where are you reading? Yes, yes. Hostile, yes.
Before me, that since earlier his son, Sajan Mura, used to beat his wife, Anima Mura. PW 4 further stated before me that on previous night of occurrence, after coming home, he found his daughter-in-law Anima Mura in a critical condition, and thereafter due to continuous assault. There is no crack in the skull, only hemorrhage is there, blood clotting is there. If you had beaten with some weapon lordship, it would crack would be there lordship, but only hemorrhage. Found his daughter Mula in a critical condition, and thereafter due to continuous assault by his son, she died. Later on, we have changed his version lordship. But lordship in 161, at that relevant point of time, lordship he has admitted. Even PW 5 also admitted.
Let us see the contradiction at of PW 4.
Lordship, page number 15.
15.
Lordship.
You did not even prosecution. What was your cross-examination?
This is not a fact that I have stated before the police.
He is denied this. It's not a proved contradiction. If you would have said yes before police had said, he is denied.
So for that lordship, he has.
That 161 will have no meaning. 161, you can give meaning only when in a contradiction, the same is admitted. Now, that has not been admitted.
For that reason only we have been hostile. But lordship, this concession already said with the medical for death is well, and the circumstances change is also completed. And PW 2, she have also seen the previous injury. In the PM report, I'd like to confirm that lordship has only page number 70 lordship,
70.
70.
Yes.
Membrane, congestive, diffuse, and subdural hemorrhage present over the vein. There is no any lordship. Only hemorrhage. So it could be happen with the piece. If object is used lordship, then there I mean, by small lordship, there will be some. These lordship can damage the surface of the skin and. For that only lordship in case number 16 and it is mentioned lordship. That on dissection, clothed blood found in layer of the scalp and red in clothed blood was found.
Yes.
And they invite us because they don't have any animal.
You have said that. You have already said that.
Lordship already, lordship has gone to lordship, so I will not go any. I rely to the lordship one after one for extrajudicial completion and one lordship for circumstantial evidence.
Which one?
That is lordship Balbir Singh. 2023 SCC. That's 1261.
2023.
Where lordship, in para 58, Savaldas is also,
Paragraph.
58. And lordship 38, 57. And 58.
37, 50, 57. Madam, we have told you, we did not give the entire copy, just give the relevant paragraphs. No need of wasting pages like this. We have soft copies. You just can give the first page and the relevant paragraphs. Those pages. 37.
Lordship regarding motive lordship. Chapter 22, SC 1045. Paragraph 67. Ramananda Mandalal Bharti Bharti State of Uttar Pradesh.
Para?
87. if an extrajudicial completion can be relied upon. So I feel that judgment may be upheld.
The earlier judgment, Balbir Singh, is those paragraphs are mainly on 106 of the Evidence Act, not on circumstantial evidence. Paragraph 37, 57, and 58. 30? You said 37, 57, 58, 38. No, not 38. 38 is a 1-on-4 presumption. These are all the discussions in 106 of the Indian Evidence Act. Okay, anything else? That's all, madam? Continuing with his arguments, Thomas B. A. Colita learned amicus curiae has concluded his. Continue with the hearing. Concluded his arguments. So also heard Miss E. Begum learned APP. Para hearing is concluded. There is going to be result. We wanted to have the instructions regarding section 21. What is this kind of instruction? You are a law officer, you are putting this instruction in the court, putting executive rules of executive business above the statute. Who is this officer? No, who is this officer? Is he a conversant with what is the legal system? He puts rules of executive business above the statute. Can it be done? How do you overcome Rule 21? No, if it is no sanction, you say no sanction. Can you justify with this? First time we have come across this kind of an explanation, probably you also. Unfortunate. Put this on affidavit. We'll take this person to task. Put this on affidavit. We'll put this on record also. Now put this on affidavit. Let this be on record. It's good, very good. Rule 21 goes for a toss. 6er out of the gallery. No requirement. Remove it from the statute book. Put it on affidavit. Put it on affidavit. Heard 3 M. Dutta, learned counsel for the petition. Also heard 3 D. Nath, learned senior advocate Assam, as well as 3 S.K. Methi, learned standing counsel accountant general. Para. On the last occasion, that is 5/5/2025, instructions. Instructions were directed to be obtained with regard to the aspect of compliance of Rule 21 of the Assam Services within bracket pension rules 1969. So in fact, such direction was also given on earlier occasions. Sarah, be that as it may, Sri Nath, the learned state council, has placed before this court written instructions dated 8 May 2025. The from a reading of the same would give a clear picture that Rule 21 of the aforesaid rules was given a total go by, and the justification has been sought to be made by taking into consideration by referring to Rule 7, Rules 7, 9 and 12 of the Assam Rules of Executive Business 1968. Let the said instructions be submitted before this court by way of an affidavit, which is to be filed within 2 weeks from today. The written instructions placed before this court is made part of the records. 2 weeks. Yes. Item 2. Yes. Finally. (21/4/2025) was the last date, Mr. Fukan. We are in 8th, we're to the 8th of May. Okay, some more time will grant. Okay. Heard. Miss S. Kanungo, learned counsel for the petitioner. Sarah. P.J. Fukan, learned standing counsel. Of what? What university? However, please for some more time to file the affidavit as directed by the last order dated 21/4/2025. Para, as paid for, least after 2 weeks, to enable filing of such affidavit.
Item 3. The application resolution submitted by the petitioner or
With all respect to my. Approval order my family diabetes. My lordship can dispose of the.
What was your cause of action?
One of the cause of action is that I tendered a resignation after without accepting with them after a period of 5 years, they have initiated the departmental proceeding.
Okay,
Their departmental proceeding I have to see the challenge.
okay.
Once I have tendered my resignation, it was either they can accept it or reject it. But since it is on hold, not they the department. Now, as my learned friend had taken.
Now, if the resignation is accepted, it will be from which date?
Not from the year 2017, from the date of.
Mr. Upamanyu?
Okay, but it is taken up or where. Let me have a review of it.
You are referring to FR 56. Which one?
On of the resignation letter, I have written page, you know. The 24 elected form.
20?
24, you know, elected form. And then,
Are you invoking deemed resignation?
not the, as I have submitted the resignation by following the due procedure of law. They can accept it or.
What do you want? You are aggrieved by the initiation of the DP.
Department.
Are you in service?
I am not.
No, what do you want? You want acceptance of your resignation.
No resignation.
Are you invoking the doctrine of deemed resignation? Where is the case law?
That I'm not able to.
Why? Where is the case of Sangma?
Yes.
The case went to the Supreme Court, judicial officer's case,
Yes.
should be aware. Heard Sri A.R. Bhuya, learned counsel for the petitioner. Also heard Sri D. Upamanyu, learned standing counsel, Health and Family Welfare Department. Who however submits that certain instructions have been received by him over telephone on the aspect of resignation, on the aspect of acceptance of the resignation of the petitioner. Full stop. He however prays for some time to receive the instructions in written form. Para, list after a week.
Thank you. Problem.
Item 4 and 5. Yes, madam, what is this? Who is free? You appear for the principal. Okay, file your affidavit. We grant you 10 days time. You file it. Okay. After 10 days, madam. Okay. Third, Ms. S. Borpatra Gohan, then counsel for the petition. Also heard higher education, Ravildar. Also heard Sri Ravildar learned training council, higher education department. This one number 7, your name is not there. You have not filed Wakalandama. You have not filed your Walandama. You are DC na. Here is this 104 is written. Okay, the Sri DC Nath for the private respondent, as well as Sri Sharma, learned counsel for the principal. All right, so for the principal and college. For the principal and authority of the college. Sri Sharma, learned counsel, submits that the affidavit on behalf of his client is ready and will be filed shortly. Puts the list after 10 days to enable filing of the affidavit. Okay, list on, the list of 10 days, give a date. Today is what? 9th. We'll have it on 19th. Okay. List on 19th. Is there any interim order, madam? Interim order stands extended, if an stands extended till the next date. Interim order, if any, stands extended till the next date. 20. 20. Mystery. Item 6. Heard Miss A. Buzarbura, learned counsel for the petitioners. Para. 3B. Chaudhary, learned senior counsel BTC. However, submits that the affidavit in opposition is ready and affidavit opposition has been prepared and has been sent for vetting. Para. He accordingly pays for and is granted 2 weeks time to file the affidavit. Fukan for which elementary? 3A Fukan learned senior counsel education, elementary education is present. Then 7 and 8. Yes, 7 and 8. Mr. P.R. Sharma. Who is P.R. Sharma? D. Medhi. S. Tegu P. Naidin. What is this, Mr. Chutin?
So
They are what? They are colleges, schools. These persons are principals of the school. Schools have not come.
they have a great party. The president of the school, I think.
President is espousing the cause of action. Where are they?
Against this order, by the secretary, there is a motion for appeal in the court. He has not availed.
Who is P.R. Sharma? Okay. None appears for the petitioner on call, whereas, yes, P.R. Sharma. Yes, what is this? Affiliation, yes. Notice issued, affidavit exchange. Affidavit exchange. What do you have to say? Sit for a while, sit for 1 minute. After 1 minute, we'll take your case. $32. Yes.
This order was passed. So the complaint was filed in on 19th of February 24.
25.
Yes, yes.
Yes.
My lord, in this concept, my lord, the name of the employees of our school, my lord, namely Mr. Manoj Kumar Tegu, Ramesh Kumar Tegu, Mr. Dennis Power, where he,
Hmm.
whereas in the issued order, they named the name. And my lord, this, the issued order is page 32, my lord, was passed in a case manner, not according to the proper opportunity to focus.
Yes, what do you say, Mr.?
Directive of the secretary of public order is for to. So there is a provision for actually why he is the department
Appeal under?
under. It is that exercise, but my one time.
Just a minute.
23. Any institution is school. Madrasa agree with an order permit the authorized officer of the board in connection with the deposition or circumstances. As specified in the regulations that approve the board in the form of at least 3 months from the date of passing the order. The board decision shall be final.
But did you give them any chance?
I read it, second is overall. Hospital done the waive the time,
No. Did you give them any chance before you took the action?
Madam.
Did you give any opportunity to them?
Oh, yes, madam, appeal.
No, we are not in
Oh,
the
yeah,
question
for passing this
of
order.
passing the
So
order.
on receipt of the inquiry report, one of the regulations, there is a madam provision.
Where is the inquiry? Where they are made?
Inquiry report is not amended.
No, in the inquiry made, where they take into confidence their versions were taken.
The matter is inquiry report, I think, given by the inspector.
No, was there a response sought for?
That is one of the report, which I don't have the record line.
Doesn't appear. Doesn't appear. 19.2 is the complaint, and 23.2 is the cancellation.
I don't think.
Give them an opportunity, then cancel it. Yeah, and the other one,
Similar matter, my lord. My lord, may kindly have the other side.
similar.
Similar, my lord, it is full.
Okay.
Grounds are similar, and I think on the same complaint, 19 complaint.
That complaint was before the police.
My lord, that complaint was before police.
What happened in the police case?
My lord, now we are on bail, that is something. Their case is pending. And it will page 36, annexure 6.
Okay, heard 3. At first, generally, the second one. Heard 3. PR Sharma, learned counsel for the petitioner. Also heard 3. TC Chutia, learned standing counsel.
SSD.
Huh?
Some state school.
Assam State School bracket Earth Soil SEB.
Yes.
SEB, huh? And the education department? Master and so. Learned, who is the response number 5? 5. For education department. None appears for the proforma respondent upon whom service has been affected. Para. Considering the affected, and in this regard, an affidavit for dusty service has also been filed. Considering the nature of the dispute raised in this petition and also the exchange of affidavits, the present petition is taken up for disposal at the admission stage itself. Para. The petitioner is the president of the School Management Committee of Murkok Select Collegiate High School, Junai in the district of Dhemaji. It is averred that the school was established in the year 1994 and presently has the permission to conduct classes up to what? Up to class 10. The school was also allotted UDISE code and SEBA code, and the functioning of the school has been going on in a smooth manner. Full stop. However, on 19/2/2024, while the HSLC examination of the state was going on, one complaint was lodged before the Junai PS in the form of an FIR, which was registered as Junai PS case number 17 of 2024, corresponding to GR case number 20 of 2024. Full stop. However, in connection with the said complaint, the impugned order has been passed almost immediately thereafter, cancelling the affiliation of the school in question with effect from 1/4/2024. Please have your seat. Para. Shri Sharma, the learned counsel, has submitted that the aforesaid action is absolutely arbitrary, unreasonable, and in gross violation of the principles of natural justice. He has submitted that the affair itself was against one particular individual, and without even the criminal case being brought to a logical conclusion, the affiliation of the school was cancelled within a span of 4 days from that date. He has highlighted the aspect that no opportunity of any manner was granted to the petitioner school, to this petitioner, for taking the impugned action, which has adverse civil consequences. The learned counsel has also submitted that irrelevant and extraneous considerations appear to have been taken while passing the order, impugned order, and it was obligatory on the part of the respondent authorities to issue appropriate notice asking to show cause and give adequate opportunity. Para. Per contra, Sri Chutia, the learned standing counsel, has submitted that has defended the impugned order and has submitted that gross irregularities were found in the part of the school and its employees, which had facilitated for unfair means in the HSLC examination of the year 2024. He has, however, he has submitted that strict action was required to be taken, which has been done by passing of the impugned order. Para. The learned standing counsel has also submitted that the regulations holding the field also provides for referring an appeal by the aggrieved person and without without exhausting such remedy, the present writ petition has been filed, which is liable to be dismissed. Para. The rival submissions have been duly considered. Para. It is not in dispute that the impugned order is an outcome of the complaint of the police case lodged 4 days before the impugned order. The complaint was lodged against a particular individual alleging malpractice in the ongoing HSLC examination, and it is on record that the said criminal case has not been brought to a logical conclusion. It has also been informed that the accused persons are on bail. Without even going to the aforesaid aspect and the veracity and correctness of the allegation, it is seen that the impugned order has been passed without affording any opportunity to the concerned school and the connected personnel. Chukia is correct in pointing out that there is a provision of appeal which has not been exhausted. However, the said contention would not hold good in the present case, as admittedly there is gross violation of the principles of natural justice. In the landmark case of Whirlpool versus so-and-so, the Honorable Supreme Court, on the aspect of availability of alternative remedy, has clearly laid down that such availability would not be a bar to invoke the writ jurisdiction if there is gross violation of the principles of natural justice. For ready reference, the relevant observation is expected here in below. In view of the aforesaid position of law, and also the undisputed fact that no opportunity of any nature was given to the petitioner before passing of the impugned order, the same is interfered with and set aside. It is, however, made clear that the present order would not be a bar to take action in accordance with law. Writ petition stands allowed. Next one, same. He is also the president. For ready reference, appeal is expected. What is the name of this?
I don't name him, my lord, Ryan.
No. Mr. Putia? What is this? What is the name of this regulation? Regulation of permission and recognition of schools of the board 2016. It was 75. And this is regulation 23. Board of the board 2016. 75 already. We'll have this book from our
correct.
We have not restrained you from taking action. You take it in accordance with law, but not like this. Yes.
Like that. I think like.
Okay, notice was issued only, okay. Heard Sri I. Chaudhary, learned counsel for the petitioners. You are also challenging withdrawal of affiliation. Ms. R. Bora, learned. You appear as CGC or what? Learned CGC. Oh, senior. Oh, the learned standing counsel, CBSC. However, submits that the affidavit has been prepared and would be filed shortly. Full stop. See accordingly prays for and is granted 2 weeks time. A week's time to file affidavit. List after a week. The interim order passed earlier to continue till the next date of listing. We give a date if there's an interim next Friday. List on 16th. Madam, we file it before that 16th and furnish copy. Yes, next.
Item 10.
Who are you, madam? UGC. Okay. Yes.
Evidence is filed by the higher education. Last question.
Okay. Mr. Das here for higher education. You have affidavit filed. How many matters? One matter, two matters?
One minute.
One matter, the number of petitioners is 17.
What is your case, Mr. Pal?
There is a petition before one, summarizing paragraph 41.
What is it?
Constable signed at place 401.
Now, what is it? Tell us. Don't go to the pleadings. In brief, what is your case?
The present petitioners are working in the grade of assistant professor, in the post of assistant professor.
Where?
In their respective colleges.
Okay.
But due to not having any associate professor in that college, they have been given the post of in charge since considerable length of time. And in the meantime, after since last 14, 15, 16, 18, 20 years of establishment of the colleges, no post of principals have been published. But what happened in this case, very recently, after filing of this invitation, higher education department started to circulate advertising in respect of the post of regular principal. That is our limited figure because number of it, among them 17 petitioners, at least 12 to 13 petitioners are processing with PhD, which is
Now, what is the difficulty in participating in the regular selection? You participate.
that department of you pay when 2 or 3 years the relaxation in consideration of qualification for the to be get qualified for the regular principal. That it would be a good relief for us.
Now, can it be done by violating the UGC regulations?
No, man.
Yeah.
There is some provisions of regulation. The higher education department itself. In the case of future principals matter, higher education department exemption 5 years exemption. So please pray for some difficulty.
Yes, what do you say, Mr. Das? Yes. No question of regulation will not come at all.
They are asking to regular.
How can it be done, Mr. Paul? You take part in the recruitment process. You apply for age relaxation, will direct for consideration in accordance with law. But how can you? Is there an interim order?
No, right, my lord.
And how do you join together? How do you join together in a common petition?
There are various colleges of Assam are related with their various problems. In this way, they are.
Oh, no, you cannot join cause of action like this. You have got, these are individual causes of action. You are seeking your regulation or whatever in that particular post which you are holding. How do you join together?
Right, my lord, some are qualified, some are not qualified. They are seeking qualification only. Clearly stated in this individually. You get their qualification, their methods, their entitlement, everything has been clearly verified.
You don't think there is anything in this case?
Right, madam, I'm not allowed, but I can. Based on, that's what this program is. Similar line, but this program. That is, we are not party.
Not necessary. Not necessary. Please show it to your colleague. Please show it to your colleague.
I am also with my additional.
Then if that is the conclusion arrived at by this court, how can you take a different? Otherwise also, we'll say that you will be allowed to participate if you have the eligibility. And if there is a provision for relaxation of age, that will be considered in accordance with law.
After 10 years, 14 years of experience, that is considered.
How can we say something which is not permitted by law?
Attending 12 to 13 years, that's the part of attending qualification. That's what this limitation.
Hard facts will not make us take a decision which is against the law. If the law says you need so much of experience, you need to. And if there is a scope for relaxation, we'll say, we'll apply.
Tutor principle may be considered in our case.
Tutor principle, what is tutor principle? This one.
27 July 20.
Okay, we'll do one thing. We'll dispose of this matter, but let madam file the. What do you say?
They're not entitled to absorption of regularization. And
We thought she would be supporting you. She's also not supporting you.
We are not disputing the eligibility of qualification for which you have been
This
implemented.
is unfair, 1 versus 2. Unfair.
mandatory in all universities and colleges. So my role in this, you don't know.
What is that case, Kerala case? It was placed by one of your colleague in one of the other matters.
Giving some readings to the petition.
Lordship, until
What kind of video? Tell us.
Your lordship suggested. So, what I understand. If they are not awarded, they are already assigned because of concern authority.
Happy?
Lordship may dispose of it.
No, his suggestion, Mr. Das. Suggestion of Mr. Das. Is it okay?
Whatever be the good for the, that's the justice.
What is IA?
I am for suspending the version of
The recruitment process, what is the stage?
in some colleges, 2 or 3 colleges, my learned friend will clearly say, vacancy has been filled up. And rest of the colleges, interviews are on process, but the candidates finally not finalized.
Have you applied?
I have not applied. We have filed this application due to pendency of.
Then if you have not applied, how will you be considered? You have not applied.
How can we apply, madam? Because in the.
No, filing of the writ petition, is there any bar that if you file a writ petition?
14 years of experience is required as assistant professor. So we have.
years of experience.
No, is there a clause for relaxation? This 14 years.
Because.
No, you are saying that some clause for relaxation is there. What is that clause? Then relaxation of age only, age. Mr. Pal, if you have not applied for even, what order are you expecting us to pass, which might give you some relief? Why did you take a chance? You should have at least applied for the post. Some observation of any, of relaxing age or whatever, of the experience which you have gathered, 14, 15 years you are saying, you could have made some observation, considered.
Our legal difficulty is that, madam, being a principal, I am also a member of the governing body. Of the college. So we are challenging and integrated as governing body, yes, and we cannot again participate in the same some contribution, conflict of interest appearing here. No, not.
You think how you can dispose of this matter? We'll grant Madam 2 weeks time to file affidavit, okay? What is the name? Just no, there's one more. There's one more. It was made by one of your colleagues. No, there is. Okay, you do one thing. You will file and place those. Okay. Part 3. This is by you.
Yes.
Part 3. For learned counsel for the petitioner. Also heard 3 as thus learned Standing Council Higher Education Department and Dr. P. Agarwal, learned Standing Council, UGC. While the Higher Education Department has filed affidavit, the UGC is yet to file affidavit. Full stop. Dr. Agarwal, the learned Standing Council, prays for 2 weeks time to file the affidavit of opposition. Please, after 2 weeks to enable filing of such affidavit. The matter, as suggested by the learned counsel for the parties, an endeavor will be made to dispose of the matter at the admission stage. 2 weeks. You can try. Date. Yes, tell us date. Yes, madam, tell us the date. 29th. We can have it on 28th. Is it okay for Wednesday? You please take back your. Okay, next. Item 11.
In this case,
Yes.
that has seniority. By annexure came documents and also dated December 44.
Seniority of
Seniority of the private responsibility, not patent.
appeared.
No, that's not the reciprocal notification of the amount.
Oh, it is deemed to be complete.
Right.
You're right. Yes, Mr. Das. File the affidavit 24 matter.
Then that's not based on corporate seniority, not his certificate of education. Presently, he is working as
Heard your yearly.
Right.
Heard 3 yearly learned counsel for the one petitioner.
Right.
For the petitioner. Also heard 3 as does learned Standing Council, Higher Education Department, who prays for and is granted 3 weeks time to file the affidavit of opposition. Yes, next. Item 12. Say is the same cause of action, different. Okay, same order. 3 weeks time to file it. 13. You are for the Guwahati University. Your affidavit has come. Has it come on record? let it be on record. Heard Sri M. Sharma, learned counsel for the petitioner. Also heard Sri V.J. Fukan, learned standing counsel KKHSOU, who has submitted that the affidavit in opposition has been filed today, which however, today, full stop. Since the said affidavit in opposition is not tagged with the records, the matter is adjourned to be listed for admission along with the affidavit on Friday next. 16. 14. Yes.
Here is the proposal for giving the in-charge is submitted by the inspector of schools at page 18.
Proposal for in charge
In-charge principal.
of a school or a college? School.
Submitted by the inspector of schools on 16/1/2025.
Yes, madam, sorry.
This was at,
The seniority list is next to page 16 or there we'll see that above the petition there is another issue with senior.
Yes, how do you overcome him?
but not actually eligible. Some eligible to
Where is your proposal?
proposal at page number 18.
1-8. Who has given the proposal?
Inspector of schools.
What is your name? Pradeep Devnath. Pradeep. Dipamoni. Where are you in page 18?
Page 16 your lordship.
No, 18 you said is the,
18 it is general,
where is the proposal?
this page 18 is the providing order. Page 18 is the providing.
Where is your name?
My name is in page number 16, serial number 3 madam.
Dipamoni.
Yes.
And about the petition.
Pradeep and Gitumoni.
It is not, he has given his consent as anyone.
And Gitumoni?
And when he is not eligible as per their color,
How do you say?
because in the remarks, it is mentioned madam.
Okay, here,
The action is nowadays not allowing the persons to hold the charge, though this court has already decided the issue. Those who have persons been in violation of the rules 13 of the 1965 rules, they are not allowed to hold the charge. And the petitioner thereof is the otherwise eligible qualified.
I would like to inform. Honorable. No, see, madam, this Inspector of Schools Nagaon has issued a communication on 16/1/2025. It has not specifically mentioned the name of the petitioner. He has simply asked for, inform the director to take steps to fill up the post of the in-charge principal. And he has also enclosed a list, a seniority list, where one comment has been made that so far as the incumbent against serial number 1 is concerned, he has expressed his unwillingness.
yes,
And you can go ahead with the. So if you think that above the petitioner, one Gitumoni Bora is there, you appoint her. If not, then appoint the principal.
Yes.
yes, that is why your lordship, the director will take a fresh call now.
Yes, we dispose of this.
Yes,
No point.
Yes.
Otherwise, on the authenticity of the documents, you have the instructions. These are okay.
but, that instruction is not, do not have the instruction.
So what instructions do you have?
The instruction is that, okay,
Now, what do you have? This communication by the inspector of schools is okay.
communication, the seniority list is okay about.
Then it is fine.
Yes.
Heard Sri B. Purakash of Learned Counsel for the petitioner. Also heard. There is no private respondent, Mr. Purakash, no? Also heard Miss Mushari, Standing Counsel. Standing Counsel, Education Department, secondary for all the respondents, considering the subject matter involved and as agreed upon by the learned counsel for the parties. The instant writ petition is taken up for disposal at the admission stage. There. As per the facts projected, comma, the petitioner claims to be the senior-most postgraduate teacher of the, what is the name of the school? KB Higher Secondary School.
In KP agent.
No, KB's Higher Secondary School, Dhing, in the district of Nagaon. The claim of the petitioner is that it is projected that the post of principal of the school has fallen vacant, and in this regard, the in charge principal by communication dated 6/1/2025 had informed, I had given the seniority list of the teachers to the director of secondary education Assam. Para. Subsequently, the inspector of schools, Nagaon District Circle, wide communication dated 16/1/2025 had forwarded the seniority list of teachers of the concerned school. Full stop. He has also informed that so far as the incumbent, who was the senior most in the said list, comma, he had submitted his unwillingness to take the charge of the principal due to personal reason. Full stop. The inspector of schools had accordingly requested to allow a senior teacher to hold the charge of the post of principal as per the list enclosed. Para. Sri Purkayastha Learned Council has submitted that he is the senior-most eligible to hold the post of principal of the school, and therefore the proposal is to be acted upon and he be given the charge of the school. Para. On the other hand, comma, while Ms. Musari, the Learned Standing Council, has submitted that the proposal in principle may be acted upon, comma, the seniority list would itself reflect that there is one more incumbent above the petitioner. Full stop. Para. In his rejoinder, the Learned Counsel for the petitioner has submitted that though, as a matter of fact, there is an incumbent above the petitioner, comma, the remarks in the seniority list would show that she is not eligible, that the said incumbent is not eligible. Full stop. Para. Without even going into the aforesaid aspect of the matter of eligibility, which would be best determined by the authorities, the instant writ petition is disposed of with a direction that the Director of Secondary Education shall take on board the proposal dated 16/1/2025 issued by the Inspector of Schools NDC and bring the aspect of appointing an in-charge principal of the school in question to a logical conclusion. Full stop. The same may be done within a period of 2 months from a date of 45 days from a date of receipt of a certified copy of this order. And for done, it is needless to state that the said process is to be completed by strictly in accordance with law. Represents and disposal. 15. Yes.
The instruction to the awaited the lordship, so sometime may be granted.
What is the nature of contempt when it deals with?
Cannot from the member. This depends on who can.
Okay. Uh, On, Miss, what is- huh? Miss H. Charanki, Learned Counsel appearing on instruction of 3 SMT60. Learned Counsel for respondent prays for and is granted 3 weeks time to file affidavit in opposition. 16. Sixteen. Affidavit filed. Why didn't you file affidavit? Contempt matter, madam? Then you will not appear if you are not taking the responsibility. We'll call the officer. Don't take 2 stands, madam. If you are taking time, you have to take some responsibility. We are not asking you to do the case. But if you say that I am not on record, then don't appear in a contempt case. You will be in difficulty. If you appear with the minimum of instructions. Not like this. Who is the respondent? In this case, notice was issued on 28/8/2024 and on a subsequent date, that is 28/2/2025, the respondent had appeared through her counsel, full stop. Thereafter, the matter had come up on 2 more occasions, on 24/3/2025 and 23/4/2025. Until now, the affidavit has not been filed by the respondent. Para? Today, time has been sought for on behalf of 3 SMT Chisti, Learned NJ Khatunier, Learned Counsel for filing affidavit, full stop. Taking into consideration the nature of the allegation of non-compliance of court's order, a last chance is granted to the respondent to file affidavit, failing which appropriate orders in accordance with law would be passed. List on list on 29th of May. Yes, madam, you know what to do. Item 17. Yes, Mr. Sharma. Yes, madam. Okay. And Fukan filed.
I already filed an affidavit. On the last occasion, the additional affidavit was supposed to be filed. That also is filed, huh? We even record that whether. the
Okay,
petitioner is-
while the department has filed affidavit from other expo number 7 and 8 represented by Sri M. K. Sharma has prayed for time to file affidavit in opposition. Correct? On his request, list after 4 weeks to enable filing of affidavit in opposition.
Alright.
18.
For the Rajna program, it's some case money. I'm showing that the notice to the respondent number 5, 6, 7 answer. Here we are going to.
You have taken first steps. You have taken. Today when? Do you have time? Can you record that you have taken steps?
I can send a copy of photo state and thereafter text.
Very, very dicey statement. Yes. Miss A. Buzarbaro, learned counsel for the petitioner, has submitted that first steps for service of notice upon the respondent number 6, 5, 6, and 7 would be taken within 2 working days. Sarah, let such steps be taken and the matter be listed after 4 weeks along with service report. Service report. Service report 4 weeks minimum. But take these steps. Tomorrow and Monday is a holiday. Yes, next. Item 19. Contempt.
Contempt, that is the official hardly obligated for execute the agreement. So full order is at page 28.
Yes, anyone, BTC? Mr. Das? Either Chaudhary, anyone, BTC? Third, FU board here, learned counsel for the petitioner who submits that notice was issued in this case on 22/1/2025. He has also drawn the attention of this court to the office note dated 5/5/2025, as per which the AD card has come back after the notice has been duly served. Para. Since the respondents have not entered appearance, this court, in the interest of justice, adjourned this matter by 3 weeks to enable the said respondents to appear in this matter. List after 3 weeks. Madam, we have called you. This is a contempt matter. We cannot record your name by on personal capacity, but take note of this matter. If they do not appear, they have been served. Then we'll have to call them in person.
I am saying list after 2 weeks for all cases.
Whole case 25 matter.
This one, verified, my case is the.
The 25 contempt matter, you take the details from your colleague. Two persons are there. One is the secretary, one is the principal, I think. Okay. We are not recording the later part in the order. Contempt matter we cannot do. It's up to you. But if they do not appear, please advise them. They have to be appear in person. Okay, next. Item 20. Yes, Mr. Ahmed. Bora? Then what do you say?
Their first ground, they have got on the review, on the ground that the petitioners are employees under the Assam government. That is their first.
They're just saying. You are seeking review. What are your ground? You are ready with the matter. Yes, yes, will dispose of the matter. Yes, what is it?
Regarding the first down posting. Last already. The affidavit, additional affidavit is under the LIC.
111.
Yes. There are things up plus one. There is a statement of that as per the MU signed by the additional secretary, Health and Community Welfare Department and the Director Admin, Director General of the Health Services, Bank of India, the bar unit of police.
Where are you reading? Page?
Page 101,
112.
Yes.
Yes.
Affidavit proposition filed with the director.
What are your grounds? First, let us read the order. We will just first let us read the order. How many? There are many petitions.
There are other for the 661.
Okay. How many petitions were disposed of? You're in 661.
Yes. There are nine pairs of this
Of the petition of the judgment.
Yes. There are 9 pairs. And 17.
9.
Yes. Very
Yes.
Per contra, from usually our we are appointed by the contractual basis. With the lordship, they are as per the MLO, they are obliged to create sanction for contract according to their lordship process. So in paragraph 9, lordship, per contra, see for all other decisions of the health department has submitted it. The projection made in the requisition on fact is not correct. It is submitted that while it is correct to contend that as an MU was entered into on 25 Jan 2010 to have barred in this at Hubli, Nagaon and Guwahati, the recruitment of the petitioner at the Chitri Civil Hospital was on contractual basis and done by the hospital management society and not by the department.
Yes.
Yes. This is for the first one, okay. And to substantiate lordship, second lordship, paragraph number 10. So far as the issue of salary is concerned, he has submitted that the government has passed an order on 20/9/2020 and pursuant to the state directive, the contractual service of the petitioner was discontinued and things such discontinuation, that is 31/3/2021, the salaries have been paid. Drawing by the attention of this court to the affidavit in opposition filed by the health department on 9/2024, Learned Distance Council has submitted that the civil hospital building was demolished for construction of the medical college and hospital, and the project under which the petitioner were inducted was a pilot project in which there was no sanction force, and induction in service was done by the hospital management society that too on contractual basis. Paragraph 11 of the Learned Distance Council has also referred to the affidavit in opposition filed by the Director of Health Services on 25/2024, and by drawing the attention of this court to paragraph number 3, whereof he has submitted that in March 2014, the parliament was started in terms of the advertisement made by the Hospital Management Society for Contractual Services. He has submitted that the Hospital Management Society is itself not in existence today. There is absolutely no scope for regulation of service of the register under the project which is not in existence. Page number 17. Paragraph.
Page number?
Page 130.
Paragraph 17.
17.
Yes. Please. Yes.
The decision to induct the services of the petitioner is an outcome of the annual of 2010, pursuant to which the Hospital Management Society had recruited the petitioners on contractual basis. The said project itself was a pilot project. The decision to have a larger and better medical facility for the three medical college and hospital cannot be found fault with. Some decision automatically led to discontinuation of the three civil hospital and building itself was discontinued, which is an admitted. Under those circumstances, the claim of the petitioner does not affect the justify either for the regulation of the service or payment of salary post 31/3/2021. Regulation in service cannot be made as a matter of right, more so when the intervention service of the petitioner were not by a recruitment process initiated by the department, but by the Hospital Management Society under the pilot part in the project.
Yes.
My case is that the petitioners were recruited by the department, and then started communications of the creation of the post, and only on the lordship to construction of the Guwahati medical college and hospitals, the building were dismantled, and that does not lordship create any bar to discontinue their lordship service also. And this discontinuation notification also is stated by the Honorable Court in an INS and in 2021 also. And there is no direct order for abolition this post. And this post is still exists, and the project itself exists. But I like to draw
First, the page number 77. Under that one additional regulation. Under that one, two, three. Point number of the 112 next page. Internal standard of it. Point number 3 is of course one. There is a clear indicated as per MOU signed by the additional Secretary Health and Safety Welfare Department.
Paragraph
Paragraph number 3 is of course one.
3.1
Yes,
at 1 and 2.
yes. 3, 1, 3 is of course one.
Yes, please.
That as per MOU signed by the additional Secretary Health and Family Welfare Department, the Deputy Director Director General of Health Services of India, the bar unit of Hooghly City Hospital is started in March 2014. The then District Commissioner Hooghly and the Joint Director of Health Services Hooghly jointly issued the advertisement published on 1/14, inviting the application for engagement in the post of dresser, physiotherapist, driver, worldwide, Sapai Kormosari on contractual basis for power unit of civil hospital Hooghly. Accordingly, interview was conducted and selected candidates joining the respective. Lordship was jointly lordship and recruited. And lordship, take of shame. Annex 31, page 77.
Yes.
This is the lordship communication between the department. Okay? From the Director of Health Services, Assam, Bhangrawari, to the Deputy Secretary to the Government of Assam, Health and Family Welfare.
Yes.
Subject. Proposal for creation of post for bar unit of civil hospital under National Program for Prevention and Management of Bar. With reference to the subject and letter mentioned under reference, I have the honor to submit this proposal for creation of 25 number of posts for bar unit of civil hospital, which was started under National Program for Prevention and Management of Burn Injuries. This is the annual MPPMDI since 3/3/2014. In this connection, a statement showing details for creation of posts and guideline of MPPMDI are enforced as per discussion in the meeting held on the Secretary. And there was in the reply to that topic on page number 79 and it's 30. It is topic from the Deputy Secretary to the Government of Assam, Health and Family Welfare Department to the Director of Health Services. Third, with reference to the subject cited above, I am directed to request you to clarify whether the proposed creation of posts for bar unit of civil hospital is for permanent investment, absorption, regularization, the contractual discharge of the state to this department is department at an early date of further necessary action. Yes.
This, how is this page 79 connected to page 77?
Yes. Because there is there's some clarification.
No, page 77 is the letter number is 954,
Yes, sir.
24/2018. And page 79, where is the reference of 954? 24/2018.
fact, Lordship, this will be clear. Lordship, one affidavit, Lordship, in the directive application, but the salary was not given. In their application, they have also clarified this only. By an affidavit.
No, we just want to prima facie be satisfied.
Yes.
That 79 is connected to 77.
Yes.
These two letters.
Yes.
77 is 2/4/2018, which is a prior point of time.
Yes.
So in the subsequent letter at page 79, which is 24/7/2018, if this letter is in response to the earlier letter, the number of the letter and the date of the letter has not been mentioned. There is some other reference at page 79.
79 is 2018.
Page 77 is 2/4/2017/18. 79 is 24 July 2018.
Yes, 79. Lordship, I think this is the part 77.
77 has to be referred in 79 if
Yes.
79 is the response. Come to 79. Where is the mention of 77?
Yes, but there's another letter of the head of it. This there's a thank you for the answer.
Seventy-four.
There is also another communication. It is from 2017. 12 June 2017.
74, yes.
Yes.
Hmm.
From the Director of Health Services Assam, elaborate so the during season of the government of Assam Health regarding salaries of the staff of Parliament of Police Hospital.
Yes.
With reference to the subject cited, I have the honor to furnish the following clarification regarding salaries of the staff of Parliament of Police Hospital and the presence of work that is there.
Even this has got no reference in 77,
Yes, of the page 75.
75.
Yes.
Yes.
Yes, Lordship, this proposal was given from the Joint Director of Health Services, Hooghly,
Hmm.
addressing the Director of Health Services, Assam. Proposal for creation of posts under National Program for Prevention and Management of Burn Injuries of Civil Hospitals. This is the thing. This office letter so 15/3/2024 with reference to subject cited above, I have the order to inform that the bar unit of West Civil Service functioning with effect from 3/3/2014 with the contractual staff as per guideline of terms. The proposal for creation of post of bar unit civil hospital.
Where is this 15/3/17?
Okay.
Where is this 15/3/17 on the communication? Page 75.
Yes.
Page 75, the subject and
Yes.
reference.
Yes.
Reference, you get a letter of 15/3/77, right?
Yes, sir.
Where is this 15/3/77? The earlier letter is 12/6/2017. We just want a continuity
Yes,
because
yes, yes,
subsequent letter has
77, yes, yes, sir.
70?
77 reference,
yes,
the second letter part of it.
yes.
Yes, there is a date specific 7/3/2018. The second reference. 75 and 70. Second reference. Yes. 75 or 75. And then let's see.
No, Mr. Ahmed.
Yes.
See, 75 and 77 is going from the directorate. 75, the joint director writes to the director.
Yes.
And 77, director writes to the government. There is no problem. We were more interested in the response from the government. Where is the response from the government connected with these two applications? See, 75 is a letter which has been written by the joint director of Dhubli to the director.
Yes.
So it is an inter-office communication between the directorate. It has not reached the government as yet. The government has been informed by 77, 2/4/2018. First time director informs the government. Now the response which you are trying to show at page 79, 24th July 2018,
Yes.
government writes to the director of health services.
Yes.
Where is the connection with the earlier communication?
Yes, sir. That's what I'm saying from.
We don't find a connection. Okay, you go ahead, don't be bothered.
Next, 80 page 80 also one. I think they're interrelated. Okay. Don't have to the sector of the regarding creation of post and blockchain set a second of case 82. Why this affidavit blockchain? They have filed this affidavit in connection with WBC number 7189 regarding
80,
blockchain.
82.
Yes, sir.
This is what?
Yes, okay. That's why there is lots of documentation where I have already put it. There is some clear written in this section.
It's not.
Yes, it is everything. From the Director of Health Services Assam Tengarawali to Srimati Deepavali Administration Council. Regarding information as per High Court moderator first. There is some clear information. Lordship kindly come to page paragraph number 3. That the coincidence with the government of Assam has requested this directorate to submit detailed proposal indicating fund position as well as state of account, bar in this so and so. In reply to the above top letter, this directorate has informed us government there was no bother provision for government of building so and so. However, a supplementary demand proposal of rupees so and so was submitted to the Bob for Barn in the Guri City Hospital at Tokyo and such. Paragraph number 5. After that, the jointly the government of Assam Health Department has made queries to this directorate again to submit some clear letter also. In reply to this top letter, this directorate has submitted the clear letter number 12 and etc. After that, the directorate has submitted a proposal for creation of post for the bar unit of Dhubri Civil Hospital as requested by the fluent director of Dhubri. After that, the deputy secretary to the government of Assam Health and Human Development letter number so and so dated 10/4/2018. In reply to this letter, the director has submitted clarification by letter number so and so. That the deputy secretary to the government of Assam Health and Family Welfare Department has requested this director to submit proposal for creation of post with detailed checklist for creation of 25 number of posts has their letter number so and so. Copy and plus in this different of letter, this director has issued submitted the clearly written that letter number 12. This letter was and in the departmental creation of the post.
So what are your grounds? You have to make a review petition. This is not an appeal. Prima facie. Error apparent.
Only also recruited by the hospital management, not by the department. Therefore, they have no right to get information or regulation.
Right.
Purely on their aspects, you also decided that issue, whole issue. As per my understanding, if you also consider that aspect in another way, that they were appointed by the department itself, also, they were not vendor entry lawsuit, and their initial appointments were not illegal laws. It may be irregular, but not illegal laws.
Now, where is the advertisement?
Yes.
847 method. Advertisement issued by the Hospital Management Society and page 48 onward, the appointment letter issued by the Hospital Management.
40?
47.
See, the Hospital Management Society may have the Deputy Commissioner and Joint Director as their members, secretary, but that will not make the society a department. It's a different entity. Society does not exist today. The communications which you are trying to rely to show even the affidavit, wherein they have also alternatively used that advertisement has been issued by the so-and-so under joint signature. But that will not take away the fact that it is the society which had issued the advertisement, held the recruitment, and that society was manned by the joint director and deputy commissioner.
And appointments that were also issued by the society.
Where? Which?
Page 48 method. 48 onward.
Don't get so health services, one and not stuff.
Now, if the society was functioning and you have been you have been discontinued from service, matter would have been different. Society is it functioning?
There is factor because they have discontinued by policy. That's all that has been already stated. But by
No, we have taken care of that stay order in the final order.
Yes, by OL. Till their lordship, they did not make lordship in that order lordship. There is a lordship liberty to abolish this. Till that they did not abolish.
No, we have considered this aspect.
Yes, sir.
Those may not be grounds for review, it can be ground for appeal.
Yes, but
Our judgment may be erroneous,
yes.
but a mere error would not make review maintainable. It has to be an error apparent on the face. You may have good grounds for appeal.
For my sex. Because the MU is already lordship was signed, but the lordship was the MU. Lordship was signed by the.
No, sure. Sure.
Lordship, 112 lordship.
112.
Yes.
Yes.
3.1.
Yes.
As for the MU signed by the additional 6 in the health and individual welfare department and the deputy director admin director general health services government of India. They were signed by the department. They may have delegated to address the Deputy Commissioner of Hospital Municipality. Ultimately, this MU was lordship signed by the Department of Space. And there is a lordship in first lordship, the lordship next.
Yes, please.
In lordship, page 38. Lord.
3A.
Yes. There is in MU, there is some certain observation of scars to the state. The state has to submit certain things. In 38, point number 8.
This, Mr. Ahmed, we have already taken into
Yes, yes,
consideration.
But look, as per my understanding, if I go, can go appeal, this question may raise there. That is the way I file.
Okay, okay.
I'm honestly saying.
Third, Sri Ajit Ahmed, learned counsel for the applicant. Also heard Sri D.P. Bora, learned standing counsel, Health and Family Welfare Department, Para. By the present application, applicants, the applicants who were the repetitioners in WPC 661 of 2020 has prayed for review of the order dated 28/2/2025 disposing of the said repetition along with certain other repetitions. Full stop. Before going to the grounds set forth in the application for review, it would be apposite to remind ourselves the parameters and contours in which an application for review may be held to be maintainable. As per CPG section, and then latest Kamlesh Wala. Para. The repetitions were pertaining to a broad claim of salaries of the staff of the burn unit of the Dhubri Civil Hospital and also for continuation of their service. Full stop. The common case projected by the writ petitioners was that an MOU was signed by the state and central government in the year 2020. Please have a seat, Mr. Ahmed, to open a burn unit in 3 hospitals, in certain hospitals, including the Dhubri Civil Hospital. Full stop. The MOU had contemplated forming of a hospital management society, and it is the said hospital management society which had initiated the recruitment and made the appointment. It is, however, a matter of fact that the Deputy Commissioner of the district was the ex officio chairman of the society, and the joint director was the secretary, and therefore the recruitment was done under their signatures. Full stop. Consequently, the a conscious decision was taken for constructing the Dhubri Medical College and Hospital, and to make way for that and to facilitate that, the civil hospital in question was demolished, and subsequently the Dhubari's Medical College and Hospital has been constructed, in which a barn unit is also there. Full stop. The aforesaid facts were taken into consideration, and this court, while the state judgment had dismissed the writ petitions. Full stop. However, so far as the salaries for 3 applicants in WPC 7189 of 2015. However,
so far as the service for 3 applicants in WPC 7189 of 2015.
certain observations were made. Full stop. Para. Ahmed, the learned counsel for the petitioner, for the applicants, has submitted that there are materials on record to show that the entire process of recruitment was done by the department and not by the society. And in this regard, he has society. He has also submitted that this court in the aforesaid judgment dated 28/2/2025 had made some observations that the recruitment was done by the Hospital Management Society and not by the department, with further observations that till 31/3/2021, the salaries were paid, after which the services were discontinued. It was also observed by this court that the project in question was a pilot project. The non-existence of the Hospital Management Society after demolition of the civil hospital Dhubari has also been observed. Full stop. The learned counsel for the applicants has submitted that mere dismantling of the building would not amount to discontinuation of the services of the petition of the applicants. And in any case, such discontinuation was stayed by an order of this court passed in the year 2021. He has reiterated that the applicants were appointed by the department. Para. The learned counsel has also drawn the attention of this court to the additional affidavit filed by the Director of Health Services as Respond number 6, in which in the writ petition, in which a statement was made that the advertisement dated 1/1/2014 was jointly issued by the district commissioner and the joint director, which would show that the recruitment was done by the department. He has also drawn the attention of this court to various communications exchanged between the directorate and the department to show that the entire process was one of the department. Full stop. Para. On the other hand, comma. No. The learned counsel accordingly submits that the aforesaid order dated 28/2/2025 is liable to be reviewed as certain error apparent on the face of it appears has crept in the same. Per contra, comma, Ribora, the London Standing Council, has submitted that the scope for reviewing an order is very limited and confined to the parameters laid down in section 114, 114. One for red with order 47. 47, rule 1 of the CPC. It is submitted that the present application does not fall within the exceptional circumstances to maintain a review. He has also clarified that though the recruitment appears to have been done under the signatures of the deputy commissioner and the joint director, they were acting as office bearers. They were acting as office bearers of the hospital management committee, which was duly constituted as per the MOU. He has also submitted that the other aspects of the contention made in the review have been dealt with by this court in the order dated 28/2/2025, and no case for review is made out. As indicated above, the ambit and powers which a review court can exercise have been well defined. Full stop. It is needless to reiterate that it is only on limited grounds where a review court would exercise its power, which are: number one, detecting an error apparent on the face of the record; number two, discovery of facts which were not within the knowledge of the party, even by exercise of due diligence; number three, sufficient reasons. Full stop. Though the third ground is subjective in nature, the requirement of sufficiency has to be construed in a strict manner, as otherwise the object to bring litigations to a finality would be defeated. In the instant case, the primary contention is that the recruitment process was under the aegis, was done by the department, full stop. Though the involvement of the joint director and the deputy commissioner of the district are apparent, such involvement was only in the capacity of chairman and secretary of the hospital management committee. Full stop. In fact, the recruitment notice which has been annexed would show that it was the Hospital Management Society, Dobri, which had issued the same, and the appointments were also made by the said society, albeit being signed by the deputy commissioner as chairman of the society. The issue that the discontinuation or stayed by this court has been dealt with in details by details in the aforesaid order and cannot be reopened by this court in an application for review, as the findings are on the merits of the case. Full stop. Sarah? This court has also found that the grounds sought to be urged in support of the review are not fresh grounds, but are grounds which were taken in the proceedings, duly considered and answered on merits, and therefore it would not be a fit case wherein the powers of review are to be exercised. More so when this court has not noticed any error apparent on the face of the reports. In view of the above, this court is of the opinion that the present application for review is without any merits, and the same is accordingly dismissed. Okay. 21. Last. Yes.
Yes, I think that is yesterday. It's not on record.
Here for whom?
And for the documents, and the response to you.
What is your case? What do you want?
Guiding at the age of can be age of 60 years old. So non followed for his rules. While under government policy, the norm is 65 years.
You are a government college?
Cotton College was a government.
No. Now present
Now
status.
it's Cotton University. It's like Cotton University.
No, but the petitioner was an existing.
She was an employee of Cotton College, not as a government college.
Yeah.
No. While the transition was made, she was in the college.
She was in
Now the conditions which were imposed upon her, can it be less favorable?
No, ma'am. She continues as a government employee, madam.
Then?
She draws her salaries from the government.
Correct.
There are two cadres.
Hmm.
One cadre is the special cadre, which is of the erstwhile Cotton College employees. Their service conditions remain the same.
Okay.
For Cotton College State University, which was formed in 2011, madam, and later Cotton University in 2017. The Cotton College State Universities and Cotton University, they form one separate.
Okay.
The service conditions of the petitioner and her colleagues of Cotton College State, madam, they are the same. So therefore, they draw their salaries and also pension from the government.
Now, regarding the age.
Age is 60 years, madam, for the government employees, for Cotton College employees and other government college employees. Now, what my understanding is relying on is, madam, there was one particular cabinet decision raising the retirement age for medical college professors. She is claiming the benefit of that. Our contention, madam, is that it is up to the government of Assam. If they want to retain her till 65, it is up to the government of Assam. We only have administrative control over employees of the Cotton College.
What do you say, Mr. Das?
Government retirement age 60 years. Most of professors colleges of professors. Continue professor in university, university salary, but not from the government.
Also, to take them a career of 10 minutes clear, all education institutions, including medical college. The industry. Based on the guidelines.
If you clarify on affidavit, you have filed affidavit. Your affidavit also filed. Okay. Hartfree and Gotham. Done it counsel for the petitioner. Why is the application filed?
The IL option is for release of salary. May not be paid salary, due to a court's order option is still continuing option, but you have not been paid a salary
You're continuing after 60 years.
after 6 years. Sending the court.
Teaching. You have been allotted duties
To the best of my knowledge, is
or sitting in the common room. Which department?
English.
Petitioner. Also heard, we as Das, that is Standing Council Higher Education Department. Mr. Bodo, you are appearing. AG. Okay. Sri Nair for?
3 and 4.
PD Nair, Leonard, Council 3 and 4 within bracket Cotton University. And Sri Bodo, Leonard, Standing Council. AG. Accountant General, no? Fair enough. Though the affidavit filed by the department is on record, the affidavit said to have been filed by the Cotton University yesterday is yet to be tagged with, oh, it's come, it has come. Oh, it's IA.
In the IL option.
Objection.
Okay, is yet to be tagged with the records, para. In view of the above, list this case on Friday next.
Fine.
List this case on Friday next, along with the affidavit said to have been filed.
The interim order is.
Huh? And retirement?
31st.
30%.
How can you forcefully continue? No, if you are entitled, you will get everything. How can you forcefully continue? Tell us.
From a university.
What do you get? Till the next date, status quo as on today. The status quo, the order of status, the interim order, we continued. Till the next date, no? Till the next date of list. Yes. Okay.